afternoon. 382. Okay. Good afternoon and welcome to the Senate Judiciary Committee meeting of April 19th, 2022. We're going to start the day by opening a public hearing on House Bill 408 and recognize the prime sponsor, Representative Verville. Good afternoon, Representative.
Good afternoon, Chairwoman, Senators. Thank you for your time today. I'm here to introduce House Bill 408. This is actually the second time some of you see a version of this bill. This bill passed the House last year and got caught up in the COVID stuff, and so it didn't become law because of that. And so I brought it back. Again. I have a couple of handouts of just some news reports. This bill is to close a loophole in the existing law. So the original intent of this law was to prevent registered sex offenders from directly supervising or employing minors to protect both the minor and the registered sex offender, protect the minor from the registered sex offender, and to prevent the registered sex offender from being placed in a position where recidivism may be high. Mm-hmm. The House had a working group, a subcommittee working group, where all the involved parties came together: Department of Corrections, state police, advocate, registered sex offenders, et cetera. And we hammered out the language that's before you today, as amended by the House. And so I would kindly ask that the Senate consider and pass this bill. Just to give you an idea of the two examples, the first one is there was a gentleman that owned a landscaping company in Deerfield. He is a registered sex offender, and so he was hiring and directly supervising minors that were under his employ. So he was in their direct supervision, in a position of power over them. It went to court, and the courts ruled that the language of the law was not clear and that he wasn't violating the law. That case was actually the genesis for this bill. A couple of years later, it's discovered that a rides operator at the Deerfield Fair, not an employee of the fair, but an employee of the rides operation company, was a registered sex offender with direct repeat contact with minor children all day long, helping to load kids on and off these rides and check restraints and things like that. And again, the intent of the law was to prohibit that kind of thing. But the original law was poorly crafted and didn't carry out the intent. And so this bill is just to close that loophole.
Thank you very much for your testimony, Representative. I remember this bill from last year, and it's unfortunate that it got caught up into an omnibus bill. So, and thank you for bringing it forward again. Are there any questions from the committee for Representative Verville? Senator Khan?
Yeah, thank you, Madam Chair. Representative, thanks you for being here and taking a question. My question has to do with some of the food service industry, for instance. I just use it as a for instance. And a public or private employer or organization whose primary intent is to direct services to minors. And I just want to get a sense of how extensive this prohibition might be. If I'm in a restaurant business and minors come in and are patrons, is that a prohibited employment?
Yes, thank you for the question, Senator. It's an excellent question. And I should have made remarks to that point, because there was extensive discussion along the lines of what you bring up. The scenarios that we imagined when we considered it at the subcommittee and committee level was somebody working at a grocery store or a convenience store. Does that preclude them from taking those jobs? So if a registered sex offender gets a job bagging groceries at a local grocery store, and there's a minor that's running the register, could they take that job? And the answer is yes, right? This is to prohibit direct employment and supervision of the minor. So in those cases, or in a restaurant, as long as the registered sex offender is not in direct supervision or the employer of the minor, that job would be allowed to be held. So it's not the intent to prevent a registered sex offender from working in any place that minors may be. Further, we imagined a cash register operator, checkout clerk at a local convenience store. So you have minors that maybe come in after school to buy some penny candy or whatnot, because that would constitute potential repeat contact. But in that setting, the registered sex offender is not the employer, not in supervision of those minor children, and so those employment opportunities would not be barred.
Got it. It is the definition of supervision, right? That I guess I'm trying to arrive at. Yeah.
So thank you, Senator, for the. I'll take it as a follow-up question. I thank you, Senator Khan, for the question. So yeah, you're not in direct supervision of a customer. If you're a coworker, you're not in direct supervision. So it's not to negate those types of opportunities.
Let me ask directly, if I might. Yep. If I'm a wait staff and somebody else is bussing the tables, I receive the tip. I tip out the people that have been helping bus the tables. A job I once had. The busing side, that is. The point, am I in a supervision position as that wait staff person who is also then tipping out people?
Thank you.
A minor.
Yeah, thank you for the question, Senator. Well, there's a requirement that the registered sex offender notify the employer, and so it doesn't seem like it would be overly burdensome for an employer to be able to find a way that tips could be dispersed to people that are entitled to a percentage of those tips in such a way that if the person holding the money at some point was the registered sex offender, that some easy mechanism to make sure each person gets their fair share without it being considered direct supervision. If you're a bus staff, a bus staff has a manager. Everybody on that staff has somebody that they're a direct report to, and potentially even an indirect report to. And in those cases, the minor should not be involved in that. So if you're the supervising staff of the bus staff, if that's your job, and the bus staff has minors, then no, you would not be allowed to have that job. If you are a bus person, and there's a supervisor of the busing people, then the direct supervisor, is not there. So yeah, so I guess to take it a little further, because I understand where you're trying to get at. So if we imagine that at the House of Burville restaurant, that the wait staff is in charge of the bus staff, and I hire minors to be wait staff, then under those conditions, a registered sex offender would not allow to be, if the bus staff was the minor and the wait staff was the management, the registered sex offender under those circumstances would not be allowed to have that job, because they would be directing bus staff. So it depends on who the manager is and how the business is structured. the intent of the bill is not to further punish people. The intent of the bill is to have a degree of separation between registered sex offenders and minor children. That was the original intent. There's some loopholes that needed to be closed, and that's the intent of the bill. You know, will this preclude some registered sex offenders from holding some positions? Yes. They won't be able to work for a landscaper if the landscaper business owner is a registered sex offender. If you're a registered sex offender, you would not be allowed to be operating carnival rides where minor children are repeat customers. You're, as the operator, you're in direct supervision, you're in direct responsibility for those children, and that would not be allowed. So it's not as sweeping as some might fear, and we had a lot of discussion about that. But it would certainly not allow registered sex offenders to directly supervise or be bosses, employers of minors.
Thank you.
Are there any further questions for Representative Verbal? Seeing none, thank you very much, Representative.
Thank you for your time. I appreciate it.
The chair will call Representative Bob Lynn.
I have a proposed amendment, which I will see if you distribute. Thank you, Madam Chair and members of the committee. Because you had to make a choice of either saying you were signing up to support the bill or oppose it. I said oppose it, but I should make it really clear. I do support having a version of this bill. I'm very much a strong supporter of that. But I think that, Senator Khan, the questions that you raised are really very valid questions. If I could just give a very brief background. Currently, RSA 632A10 prohibits convicted sex offenders from obtaining employment or providing volunteer service in specific kinds of fields that are directed to providing services to children. It mentions teacher, daycare worker, coach, Boy or Girl Scout leader, etc. In 2019, the Supreme Court decided a case called State versus Proctor, which, as a prior representative mentioned, involved a convicted sex offender who, after he was released, opened a landscaping business and hired a minor to work for him. He was charged with violating the statute. His counsel made two arguments. First, the statute only applies to a person who works as an employee or a volunteer, not to a sex offender who offers employment or volunteer service as an employer. That was argument number one. And argument number two, that landscaping was not the kind of work that fell within the statute. The statute's definition was because it was unlike teaching or coaching or being a scout leader. The court overturned the defendant's conviction on the second grounds and therefore didn't reach the first grounds. This legislation, HB 408, is designed to overrule Proctor by prohibiting a sex offender, and I think this is the important language, from any employment or volunteer activity that provides direct services to minors or supervision or oversight of minors. So, you know, to the question, Senator Khan, your question, would a person who worked at Market Basket and a minor came through the checkout, or as a checkout person, and a minor came through the checkout line, that convicted sex offender would be providing direct services to the minor who came through the checkout line. If you work as a waiter and you're a convicted sex offender and the restaurant serves everybody, adults and minors, and you serve a minor, you would be providing direct services to the minor. I completely agree with the sponsor of the bill that that was not the intent, but the court is going to construe this statute based on what it says, not what the intent was. And this would be covered if you pass the statute as it's currently worded. You will be preventing people who are convicted sex offenders from working in Market Basket or 7-Eleven or you know, some convenience store like that, because they will have occasion to provide direct services to minors. And so then you have to ask yourself the question, you know, do you want to make this restriction so prohibitive that sex offenders, who will, all of them or virtually all of them, will get out of jail someday? Do you want to make a restriction that a statute that's so restrictive that they will not be able to get the kind of job that they typically will be able to get. They're not going to be getting the job as a head of BAE Systems or Dartmouth Hitchcock. They're going to get these kind of jobs. And if you have a statute that prohibits them from doing that, it seems to me what you're really guaranteeing is that they're going to be on welfare for the rest of their lives, and all of us will be paying for it. My proposed amendment tries to change that. It narrows the statute so that it retains the listing of the specific types of prohibited employment or volunteer service that is in the current law, but it also adds language prohibiting, and I'm quoting here, employment or volunteer activity that provides services exclusively or predominantly to minors. This would not prohibit working at a grocery store, a convenience store, or at a restaurant, because normally such work provides services to people of all ages rather than exclusively or predominantly to minors. It would, and by the way, the other language you'll notice in my bill is it covers both obtaining services as an employee and providing services as an employer. It's designed to address that second point that the Supreme Court didn't address in the Proctor case. So it covers both from the perspective of employee or employer, and it focuses in the catch-all phrase on providing services exclusively or predominantly to minors. So I suppose in the example if you ran a restaurant that really catered to minors, a Chuck E. Cheese maybe, or something like that, really that catered to minors, sure, you would be prohibited from working in that. But if it's if it's a restaurant that's open to anyone and you just might from time to time serve a minor, that would not be covered by the statute. And I would submit that you shouldn't cover that unless you want to really, unless you want to effectively, in terms of being able to get employment, unless you want to really put a scarlet letter on convicted sex offenders and say, you will do nothing. You will not work. You will have no involvement in the community. You will not be able to get the kinds of jobs that are probably the only ones that are available to you. If you want to do that, then I think the majority bill is fine. It will do that. It will accomplish that. But I think that, I think that goes too far, and that this is more narrowly tailored to get at the kind of things that you want to get at. Thank you very much. I'm happy to answer any questions if anyone has them.
Okay, thank you very much, Representative. Are there any questions from the committee? Senator Khan.
Thank you. Thank you, Madam Chair, and thank you for bringing forward the amendment. I think you've wrestled with the questions that I tried to wrestle with a little bit too. So one thing, number 3 under 1.3, I mean, this is our current statute, is current law for certification of teachers.
Right.
Is it necessary to repeat it here? I mean, do you think that that's, you cannot get a teaching certificate in the state of New Hampshire if you've been convicted of a sex crime?
You know what, the only thing I would say, Senator, and I have to be completely honest, I tried to have my amendment change the existing proposed bill as little as possible, so it was primarily Section 1 that I made the change in language. So I haven't really looked at the statute dealing with licensing of teachers. However, it might be, I don't know this for a fact, but it might be that the statute dealing with the licensing of teachers doesn't have a criminal penalty provision. So this, if that would be a reason why you might want to keep that here in this statute. And as I say, I haven't checked on that, so I don't really know if it does or not.
I'd refer you to 189, and I can find in 189 where that is and share that with you.
Okay.
So the only other question, I totally get where you're going on paragraph 1, number 1, or is that I? I guess that's I.
Roman numeral 1, I think so, yeah.
Roman numeral 1. I get it for exclusively to minors, predominantly to minors. Can you just give an example of what you mean by a predominantly to minors kind of thing?
Sure. What, for example, I would go back to my Chuck E. Cheese example. So, I mean, I haven't been to Chuck E. Cheese in a long, long time. I don't even know if they have them anymore. But my anticipation is that most of the people that go there go with children, but probably not all of them. And, there are probably some people some adults that, without children go to Chuck E. Cheese. But if most of the people go, if it's mostly catered to children, that's what it would be designed to capture.
Thank you.
Are there any further questions for the representative? Seeing none, thank you very much for your testimony.
Thank you.
Are there any other member of the public who would like to speak to House Bill 408? Okay, seeing none, we'll close the public hearing. No. I did sleep late on.
Thank you, Madam Chair. Thank you, Senate Judiciary members. Pleasure to be here with you again today. I'm Representative Mike Sylvia, Town of Belmont, representing Belknap 6. And I'm here to introduce HB 1101. HB 1101 is going to be somewhat familiar territory for you. It ended up being included in 1296, which you've heard, and has yet to be, as far as I know, acted on. And it was also previously, I believe, HB 331 from last year. A difference in last year's had a limit of $100,000, but this one has no such restriction. So this is about asset forfeiture, and particularly we are, as a state, have adopted a policy of criminal asset forfeiture, and we require for in-state process a criminal conviction before property is forfeited. As you know, there's a federal program of civil equitable sharing, which has two paths that we have previously discussed. One is joint task forces, and the other is adoption. So this bill only affects adoptions, which is approximately 30% of the cases that go into equitable sharing. And that was driven primarily by Representative Birch. We had discussions over several years in trying to narrow down what his objection was and where we came down. It was his opinion that the joint task forces should not come under this because they are involving the federal government in the entire case. These seizures made in state, under state law, not connected to any drug task force, are cases that properly belong in the state court. And in the state, we have protections for due process. We make sure that the person is actually a criminal. They are convicted before we take their things. And I think this is a very important point, and I think that we need to keep those forfeitures in state. The law enforcement is incentivized to go the adoption route because they receive up to 80% of the forfeiture when they go through equitable sharing. When it goes through the state process, they get 45%. So clearly there's an incentive, and I think that the policy of the state should be to prevent that circumvention of our state law. So being generally, I think, up to speed on this, I think that I'll end my testimony there. I've got the facts written down. There'll be testimony to specific numbers that will come after me. If you have any questions, I'll be happy to answer them.
Seeing none, thank you very much.
Thank you.
Okay, the chair will call Joseph Ebert.
Hello, Madam Chairwoman, members of the committee. My name is Joseph Ebert. It's E-B-E-R-T. I'm a major with the State Police. I oversee our Investigative Services Bureau, which are your detectives with your New Hampshire State Police. The division has sent me here today to point out one facet of this bill. There are times in which the federal government comes and adopts a case that is solely investigated by the state up until that point. And they may come to us. Oftentimes it happens through collaboration with the prosecuting offices, whether that be the county attorney or that is the Attorney General's office and the U.S. Attorney's office. And they may say, okay, we would like to adopt this case. And there are a number of reasons behind that. I know the House had asked me, well, why would they do that? There are certainly more stringent penalties in some circumstances. There can be more flexibility in some circumstances. And I think it's important to point out that when that happens, when the case is adopted, we believe that the forfeiture should go along with it. So in other words, if it is adopted by the federal government, we believe that we should be adhering to the federal forfeiture standard. If it remains a state case, then we should adhere to the state forfeiture standard. So having said that, those were the points that I was asked to make on behalf of the division today, but I'm more than willing to answer any questions that you may have.
Thank you very much for your testimony, Mr. Ebert. Are there any questions from the committee? Senator Gannon.
I think I'm pretty good with civil asset forfeiture. It's going to save me a lot if I have the feds do all the work, right? All the court time, all the expenses, and I'm going to get a bigger return. So I'm going to have a savings, right?
Yes, Senator. There is an absolute benefit, I guess. I hadn't looked at it that way.
If I do it a cost analysis, it's a win-win on both sides, both prosecutorially and on what I get. So
it certainly can be. You know, one thing I failed to mention that I really should is that the federal government has a greater reach, and oftentimes there is a real reason because of the resources that they bring to the table for that adoption to take place. It also does not, it certainly does not hurt that we, law enforcement receives an 80% return on that. There's no doubt about it that that is a benefit, and we utilize those funds to help run our narcotics unit.
I'm all set. Thank you.
Are there any further questions? Seeing none, thank you very much. your
Thank you very much for the
testimony.
time.
Chair will call Devin Chaffee. Good afternoon.
Madam Chair, and other members of the committee, the record.
Thank you.
Can you hear me now? Thank you. Good afternoon, Madam Chair, other honorable members of the committee. For the record, my name is Devin Chaffee, and I'm the Executive Director of the ACLU of New Hampshire, and I'm here to testify in support of HB 1101. From the perspective of the ACLU of New Hampshire, we were very involved when the initial restrictions on civil asset forfeiture were adopted by this legislature in 2016. It was a very well-considered decision to require that there be a criminal conviction before civil asset forfeiture be pursued in the court. It was a well thought out restriction. It was also pretty uncontroversial and very bipartisan. I believe that ultimately those provisions passed on a voice vote in both the House and the Senate. So this is very well thought out restrictions on the use of civil asset forfeiture that were adopted by the New Hampshire legislature. Essentially, what the adoption process allows is for that process to be circumvented. And it allows local law enforcement to use this adoption process with the federal government in order to avoid, in certain circumstances, the different requirements that are included under existing New Hampshire law. Now, Senator Gannon brought up some, I think, really important points about there is a financial incentive here. There's a financial incentive here for the local law enforcement to pursue the adoption process with the federal government in order to both avoid the requirements of New Hampshire law. But from our perspective, we shouldn't be incentivizing the pursuit of profit over the fair administration of justice. There is a reason why the New Hampshire legislature determined that there should be a criminal conviction before the New Hampshire law enforcement are allowed to confiscate and take away people's property rights. There is a reason why they felt that that was necessary. The legislature agreed, and there shouldn't be a loophole that creates this very significant, as Senator Gannon pointed out, incentive for law enforcement to use this adoption process. Now, I also just want to highlight that there is nothing in the law before you, in the bill before you, that would at all inhibit the ability of local law enforcement to collaborate with federal law enforcement. It doesn't do anything to prevent a joint task force from moving forward in the same way that they always had. It doesn't do anything to prohibit cases moving from local law enforcement to federal law enforcement. There's nothing in here that really will affect the ability of our law enforcement to cooperate legitimately with the federal government to take on important cases. All that this bill does is it requires that when you're dealing with these cases, you have to that New Hampshire law needs to be respected, and that the New Hampshire process needs to be respected, and that it can't simply be avoided by using this adoption process. And so with that, I would urge you to vote in support of HB 1101. Thank you very much.
Thank you very much for your testimony. Are there any questions from the committee?
Real
Senator
narrowly,
Gannon?
very narrowly tailored question for you. Would it free up my overburdened state courts if I went a federal route?
I think that the number of cases is so small. I think last year we were talking about 6 cases per year. So really, this doesn't affect the burden on the courts at all. Really, this is a matter of principle. Are we requiring New Hampshire law to be met, or aren't we? I wish that there was a simple fix to the overburdened courts, but really, this isn't going to have an impact at all.
Thank you.
Thank you.
Are there any further questions? Seeing none, thank you very much for your testimony.
Thank you.
The chair will call Ross Connolly.
Thank you, Madam Chair, members of the committee. It's good to be back in Senate Judiciary. Just for the record, my name is Ross Connolly. I'm the Deputy State Director for Americans for Prosperity in New Hampshire, and I'm here to voice our support for HB 1101. As we've heard, this committee is very familiar with this issue. Just to go back in time a little bit, in 2016, the legislature made the decision to require a conviction before forfeiture proceedings can begin. The law is RSA 617:1-A, which was passed, as the previous speaker mentioned, in a very bipartisan way, and protects due process rights of granted staters to require that conviction before forfeitures can begin. The most egregious example of that law being circumvented is the federal adoptions program. This, again, I don't want to be repetitive, but this does not affect task forces. Joint task forces make up around 81% of all the forfeitures in a 3-year period between 2018 to 2020, which is the most recent data we have. And those are excluded. So we're talking about a very small amount of money statewide across that 3-year period. It's $172,073. When you look at it, where it's the 40% back to the agency instead of the 80%, it's around $86,000 over a 3-year period of time. So we're looking at a small fiscal impact. To your question, Senator, again, and a very small impact on the burden in the judicial system. Really, this is about federalism and closing that loophole, which this legislature decided to pass as a law. Out of principle, we should be respecting New Hampshire law and still allowing law enforcement to do their very important work with joint task forces. So for those reasons, we urge the committee to move ought to pass, and I'd be happy to take any questions.
Thank you very much for your testimony, Mr. Connolly. Are there any questions from the committee? Seeing none, thank you.
Thank you very much.
The chair will call Catherine Sanchez. Good afternoon.
Good afternoon. Thank you. Thank you, Mrs. Chairman, members of the committee. I don't want to be, I'm Kathy Sanchez with the Institute for Justice. We're a civil liberties and nonprofit law firm. I don't want to be too repetitive of people who've come before me. This is, I would agree that this is a circumvention issue. I want to highlight some specifics about that. So what we're seeing with adoptions is that there's money that doesn't end up going into the drug forfeiture fund, money that ends up going to the federal government that shouldn't. There's money that ends up going to, that doesn't end up going to the Department of Health and Human Services because of adoptions. And again, we're talking about a relatively small chunk of change. So this is $172,000 from adoptions over the last 3 years for which data were available. And it seems maybe like a sizable chunk of change, but again, I don't think this is something that would negatively impact agency budgets for a few reasons. For one, again, these adoptions would be offset by forfeitures that would then happen through state courts. And of course, the bill doesn't affect joint task forces, so state and local agencies could still then join with the federal government through joint task forces that way. In addition, I sent around, and I regret that I wasn't able to print this for you, but an agency by agency table that lists the proceeds to each agency over the last 3 years. So what it looks like is a very small number of forfeitures and a very low level of proceeds that goes to agencies participating in adoption. So we're talking about like Manchester and Nashua police departments that have only done like a handful, like 4 forfeitures over the last few years. And so these are numbers that would really are very tiny in comparison to these large agency budgets. So this would not negatively impact agencies. And another point is that with forfeiture reform looming and with the potential for more forfeiture reform, this is a problem that can only get worse. So what we've seen in other states is whenever states enact a forfeiture reform, the federal adoption program becomes much more attractive because then the disparity between how good the state law is and how the federal program does not offer protections to property owners, the disparity becomes much wider, and it becomes more attractive for law enforcement to use the federal adoption program. And thank you. I'll take any questions.
Thank you very much for your testimony. Are there any questions for Ms. Sanchez? Senator Cannon?
Were you an attorney? I had a technical question for you.
I'm not.
You're
I'm
not
a researcher.
a researcher. I'm all set then. Thank you.
Thanks for your time.
Thank you very much for your testimony. The chair will call Joshua Albert.
Thank you, Madam Chair and committee members. My name is Joshua Albert. I'm a detective lieutenant with the Nashua Police Department. I currently serve as the divisional commander for the narcotics unit and have been with Nashua for over 20 years. 2.5 of those years was spent on a federal task force as a task force officer. I'm here to testify in opposition to House Bill 1101 on behalf of the New Hampshire Association of the Chiefs of Police. So I spent the majority of my career making police-related decisions that are in the best interest of the citizens that I serve. Decisions that are not always perfect, as they have to be made with the absolute best of intent and often with only limited information. But that's what police work is at its core, striving to make the best possible decision in the best interest of every person involved. Only recently have I found myself on the other end as an administrator, deciding on policies and seeking to how to best educate newer officers. But one thing remains as clear today as it did 20 years ago. A good person, good common sense, high moral character can have a drastic impact on the greater good. I've only testified a couple of times at these hearings, but have overheard a number of people give their opinions and their testimony. But what interests me most is what the doers have to say. They're the ones actually putting these laws into practice, and whether for or against, they follow the letter of the law as well as the spirit of the law. Relative to House Bill 1101, the United States Department of Justice issued an order on January 16th, 2015, more than 7 years ago, that federal agencies would no longer adopt cases from state and local law enforcement unless they were the most egregious of circumstances, involving public safety relative to firearms, explosives, child pornography. In my time as a supervisor narcotics unit, our federal partners have not adopted any cases solely for forfeiture, only when they were directly involved in the case. I would like to echo 2 points that I overheard earlier. The first is the major's point, in that you don't know where you're going to end up in one of these investigations. It may start very small, and relative to making a couple buys at a gram level, you never know where that's going to lead. And we have oftentimes seen it lead to much bigger investigations. And I could bring some of my current task force officers who work here who could speak to how far those investigations reach and how small they started. I would like to give one recent example that in talking with my sergeant prior to coming this morning, that I think fits with what's being discussed here today. We recently had a third shift officer conduct a traffic stop, middle of the night, located a large amount of drugs and a sizable amount of money. That was seized and originally seized on the state side of things. However, once the name made its way through the system, our federal partners reached out. They said that he was the target of their investigation, and ultimately they wanted to adopt the Nashua case. That is the only example I could come up with where, and that gentleman, again, being the target of a federal investigation, but one we were not a part of. So I guess I would like to close with why pass this bill when in practice the law is already working. I would ask that you find this bill inexpedient to legislate, and I thank you for your consideration.
Thank you very much for your testimony. Are there any questions from the committee? Senator Gannon.
Thank you for taking my question. So what you're saying is there's a legal thing. Sometimes we forum shop. In a state court, I might be able to not do as well, might do better in a federal. So I look at this analogous to that in these certain rare times, you maybe had $1 million, you found tons of money, and the state could keep 85%. Sounds good to me. But so you're saying it's sort of like forum shopping, correct? That in certain rare circumstances, you might use this, to use the prosecutorial abilities of the federal government and also for the financial windfall.
I think it's been testified to that there is a clear benefit using the federal forfeiture. However, in practice, I was an undercover detective for about a year. I worked in a task force for about 2.5 years. I've supervised an interdiction unit for about 1.5 years, and for the last 1.5 years, I've been the divisional commander of the narcotics unit. So that's a lot of experience of putting forfeiture into practice, and I can say unequivocally that when we look to have a federal agency adopt our case, and that we talk about bang for the buck, it is not relative to the money as much as it is as to if that dealer or distributor is to that level, the most bang for the buck comes in ridding them from the community. And the feds have some fairly significant minimum mandatories that allow us to put that into practice.
Thank you very much.
Are there any further questions for this witness? Okay, seeing none, thank you very much for your testimony.
Thank you, Senator.
Are there any other members of the public who would like to speak to House Bill 1101? Okay, seeing none, we'll close the public hearing. Bill 1493, you recognize the Do I have to repeat that?
Thank you, Madam Chair. Representative Mike Sylvia, Belknap 6, Town of Belmont. And I'm here to introduce HB 1493. In 2018, through an amendment made here in the Senate to SB 498, sought to bring transparency to seizure and forfeiture activity in New Hampshire. In seeking protections of due process rights, we are often told that there is no problem. It's difficult to evaluate an issue where there is little data available to make a proper judgment. HB 1493 will deliver necessary data which has been kept from public view. In the fall of 2020, in preparation for my 2021 bill, HB 331, I wanted to get supporting information for my testimony. Knowing that SB 498 had been made law, I went to the DOJ website where I expected to find the reports ordered under RSA 617:12. I found nothing on the website. I contacted DOJ in an email and was directed to the report produced under RSA 318B:17C Roman 2. That report provides information about the status of the drug forfeiture fund, not the information required by RSA 617:12. Another request was made for the proper report. No reply ever arrived. HB 1493 does two simple things. First, it consolidates reporting under RSA 617:12, adding a pointer in RSA 318B:17C Roman 3. Second, it removes what would otherwise be duplication and reporting by repealing RSA 318B:17-F. With these changes, our Constitution's directive under Part 1, Article 8 will give the people of New Hampshire the transparency required by law. With that, I'll be happy to take any questions.
Thank you very much for your testimony, Representative. Are there any questions for the representative? Okay, seeing none, thank you very much.
Thank you.
Okay, the chair will call Ross Connolly.
Thank you again, Madam Chair and members of the committee for holding this hearing. For the record, again, my name is Ross Connolly. I'm the Deputy State Director for Americans for Prosperity in New Hampshire, and here to voice our support for HB 1493. This bill is pretty straightforward. It just provides more transparency and the details of how forfeitures are gained and divvied out across the state. It's one thing. Across the board, we've noticed on both sides just not being able to get the information needed to really understand what's happening in the state when it comes to forfeitures. So this makes it a little more clear on what is to be provided, specifically putting that word each in, line 21 instead of the, just so we have a little more detail on each property without divulging, sensitive information like informants and things of a sensitive nature. So this is just to get a little more transparency into how things are working, especially for the legislature. Having our elected officials having this information will be valuable in the decision-making process. New Hampshire's first in freedom, but we often get ranked poorly due to government transparency. So this bill will make a slight step forward in improving that and bringing more information to both the legislature and the public and how forfeitures proceed.
Okay, thank you very much. I was going to call you Representative, Mr. Connolly.
Don't give me that promotion.
Thank you so much, Mr. Connolly. We should have the honorary title. Are there any further questions for Mr. Connolly? Okay, seeing none, thank you very much.
Thank you very much.
The chair will call Kathy Sanchez. Good afternoon again, Ms. Sanchez.
Good afternoon, and thank you again, Madam Chair and members of the committee. Again, I work for the Institute for Justice. We're a nonprofit law firm. I'm a researcher. And one of the things we do is collect a lot of forfeiture data and a lot of forfeiture records. So I absolutely love this bill. I think Representative Sylvia did a very excellent job pinpointing the exact areas that need improvement. In 2018, the General Court enacted some reporting reform, and the Attorney General has not complied. We've tried very hard to get records through right to know request. It's been very difficult. And we want to give the Attorney General a benefit of the doubt and say that maybe there's reason for the lack of compliance here. We did recognize that the specific amendments Representative Sylvia had to this were very tailored to the issues. And so, again, it repeals some duplicative and defunct requirements, and it references the new law in the old version of the statute that the Attorney General is complying under. And so the Attorney General is currently reporting on monies and on what's happening with the drug forfeiture fund, and we applaud that. But what this bill does is it reinforces the requirements from 2018, which are less about the money and more about what happened to the property itself. So this will help us get to some of those very important questions about forfeiture, like the efficacy of forfeiture, what's seized versus ultimately forfeited. It gives us a lot more detail for the public and for the general court to be able to figure out whether this forfeiture program is actually working. And so, again, we do applaud the general court for reporting on monies. But again, we want to make sure that the focus is also on the property itself, and that makes this bill makes that clearer for the Attorney General and would result in greater transparency. And so that's why you should support HB 1493. Thank you.
Thank you very much for your testimony. Are there any questions from the committee? For Ms. Sanchez? Seeing none. Thank you very much, Ms. Sanchez. Are there any other members of the public that would like to speak on House Bill 1493? Okay, seeing none, we'll close the public hearing. What is it? Oh, that's right. Oh, no. Thank you so much. Oh, he's going to introduce the bill. Okay. How do you spell your, what's up for the thing? Piemont? P. Okay, thank you. I wanted to make sure we got it correct. Do you need something, Jenny? Senator Gannon? You have an amendment?
We do. Is there no? Sure.
Who did display? Okay.
This is last week.
Thank you. Oh, yeah, okay, I've heard about this. Okay, nope, wrong bill. That's okay, so Representative Lynn, you'll be up again? Yeah. It's tough, for some reason, it's Tuesday and it's just discombobulated.
Yes.
I don't know, it's because of all the sugar from Easter, maybe.
Maybe it is.
Maybe.
Seems like
Yeah, we're one hearing behind, so that's not too bad. Not bad. Hey, are you all set, Jen? Okay. We're going to go ahead and open the public hearing on House Bill 1103 and recognize Representative Lynn, who is going to introduce the bill for Representative Spillane. It's good to see you again.
Thank you, Madam Chair, members of the committee. Yeah, I'm here on behalf of Representative Spillane to introduce House Bill 1103. It's a bill that provides that in a divorce proceeding, the court shall not require a party to sell a marital asset if the party is able to compensate the other party for his or her interest in it, and the sale is not required for an equitable division of the marital property. And I have to say, honestly, since I was not involved in that's about what I've just read to you is what I know about the bill.
Okay, thank you very much for your testimony.
Thank you.
Are there any questions for Representative Lynn? Senator French?
You know, I don't, from my experience on the court, I think that sometimes there is a problem, there can be a dispute between the parties about whether the house should be sold or who should get it, who should get the proceeds, that kind of thing. This particular issue that, like, the house should not be sold at all if the assets could be bought out in some other way. I don't recall one in particular, but I can't say that it is not a problem. Some people, maybe there are people here that have more recent experience on that than I do.
Okay. Thank you. Thank
So
you very much.
Representative, would you believe that Senator French and myself have received numerous emails saying that their assets like motorcycles had been forced for sale by judges, and that was why they brought forward this bill? Would you believe that?
I would believe, I guess what I was really sort of saying is I would believe it if it was necessary. I mean, I guess I would find it unusual if that was ordered in a situation where it was not necessary to be able to compensate the other party. In other words, if there were some other assets from which that could happen. I'm
good.
I don't know.
Okay, thank you very much, Representative, for helping us out here. We really appreciate it.
No problem. Thank you.
Okay. Are there any other members of the public that would like to speak to 1103, House Bill 1103? Okay, seeing none, we'll close the public hearing. Yeah. No. Thank you for reminding me. We're going to go ahead and open the public hearing on House Bill 1266 and call the prime sponsor, Representative Piemonte. Good afternoon, Representative.
Thank you, Madam Chair. and Thank you committee, for having the opportunity to open this bill. House Bill 1266 makes a simple change in the law to prohibit the state or any political subdivision thereof from making a policy that will prohibit law enforcement from working with the Federal Immigration Enforcement related to someone who is already in custody for violation of the state law. The bill does not allow a state or local enforcement to enforce federal immigration law or to even inquire about someone's immigration status to either in public or once in custody. It simply allows them, should they do so, to choose to respond to that detainer request by federal immigration authorities if one is discovered during the booking process. The bill is designed for a case-by-case basis and only applies when a person is in custody. No one is going out arresting people. In extreme circumstances, you would want the police to have the discretion to detain or not. And this is a good bill, and I urge the committee for a favor and not to pass basis for House Bill 1266.
Thank you very much for your testimony, Representative. Are there any questions? I just want some clarification for me. Are you saying that this, if we should adopt it, only applies to persons not in custody?
A person's in custody.
In custody?
Yes.
Okay. So if I'm just going to follow up with that. So we're not saying the state can't adopt any laws or rules to go after illegal immigrants to this
That is
country?
correct. No one is going out arresting people or anything like that. But if a serious crime is committed, it gives the police the option to either honor that detainer or not. And in most cases, they make that decision, and it would usually be the right one.
Okay. Thank you very much for your testimony.
Appreciate it.
Seeing no further questions, again, thank you.
Thank you.
Okay, the chair will call Gilles Bissonnette.
You know, I do this all the time where I submit my notes to the committee inadvertently.
Is that the attorney work product?
Madam Chair, thank you so much for the opportunity to testify today. Gilles Bissonnette with the ACLU of New Hampshire and the legal director there. We are here in opposition to this bill. And there are three main concerns that we have that I just want to outline very succinctly. First is in banning municipalities from enforcing strike that. In banning municipalities from discouraging cooperation with federal immigration officials, this bill, at least based on my reading, seems to imply that if a locality doesn't do anything that the federal government asks it to do in the immigration context, no matter how costly that may be to local taxpayers or to police departments, that they would effectively be implementing a ban policy under the law. So I don't read this as narrowly as the sponsor. And maybe that's an ambiguity with respect to this legislation. You know, on its face, it says a police department or a municipality shouldn't adopt or enforce any policy that prohibits that locality from cooperating with enforcement of federal immigration laws, period, full stop. So I think it very arguably could be read much broader than at least the intent of the sponsor, more broader than what is reflected by the intent of the sponsor. There's no in-custody criteria when you look at the text of the bill as well. So I think that is a real concern that we have with respect to this policy. And as a result, we think that this bill could be a significant intrusion on local control. And frankly, the notion that in New Hampshire, we don't require local police, local municipalities to do the bidding of the federal government.
The second concern, and it's related, and this was mentioned by the sponsor, is that this bill could effectively require, in my view, based on its language, local municipalities, local police departments to honor and require the enforcement of immigration detainers. Because a policy that would suggest that they don't need to be followed would arguably be barred, I think, under this legislation. And I think this requires a little bit of context with respect to what ICE detainers are at the end of the day. They're not arrest warrants, unlike criminal warrants, which are supported by judicial determination of probable cause. ICE detainers are issued by ICE enforcement agents themselves with no judicial oversight. And in fact, many courts around the country have explained that detainers on their face are not based on probable cause, and they don't actually require detention. But I think my fear here is if a policy proactively acknowledges those deficiencies, those issues with detainers, and says that our local police departments don't need to honor them for various reasons, that they would be running afoul of this particular legislation. And I would also note that because of these lacks of checks and balances with respect to ICE detainers, U.S. citizens have actually been held under detainers improperly, I'm sure accidentally, but nonetheless it has occurred. We cite some of that data in our testimony. Lastly, and I think perhaps most importantly, is I think this bill would undermine trust in law enforcement. And this is because this bill has the potential to make us less safe and in fact create an environment where undocumented individuals who are a victim or a witness of crime or even confidential informants are less likely to cooperate or engage with law enforcement. Just by way of example, our office actually litigated a case several years ago where an undocumented person was actually helping law enforcement with translation services as law enforcement was questioning a suspect. And after that exchange, after that questioning, law enforcement turned to that individual, started asking questions about status, and that ultimately led to the detention of that individual. And I have a real concern when you have a legislation like this. It will certainly create an environment in fear where folks who may have immigration issues just won't engage in law enforcement. And that's a concern. Law enforcement works for all of us, whether we have status or not, that whether you're a victim of a crime, whether you've seen a crime, you should feel comfortable engaging the police. So those are the three concerns that we have. We do hope that the committee deems this bill inexpedient to legislate, but I did also want to say in conclusion that recognizing, I think, all of these important considerations, we are actually leading the way with respect to creating an environment where all citizens, including those who may not have status, feel comfortable engaging in law enforcement. And we have done that in part through a state police policy that I really think is the gold standard. And I think you all know that sometimes in my role, I'm critical of law enforcement. This is one instance in which we really have actually led the way. I would hate to see us move backwards. But the state police, I think, as I said, is really put forward the gold standard with respect to fair and impartial policing. And I do have a very serious concern, given some of the language of this bill, that this legislation would actually undermine those efforts. Thank you.
Thank you very much for your testimony, Mr. Bissonnette. Are there any questions from the committee?
Just a quick question.
Senator Gannon.
Thank you.
You just said citizens, regardless of their immigration status. Are you saying illegal?
Sorry, what I should have said is individuals, regardless of their citizenship status. That was
Thank you.
a comment, a fair correction. Thank you.
Okay. Thank you very much for
Thank
your
you.
testimony, Mr. Did you have a question, Senator French?
I have many, but none for him. Thank you.
Thank you.
Good to know, Senator. Okay.
What day is today?
Okay. Next, we're going to call Major Joseph Ebert from the New Hampshire State Police.
Good afternoon again, members of the committee, Madam Chairwoman. My name is Joseph Ebert. For the record, it is EBERT. And again, I am a major with the state police. I oversee the Investigative Services Bureau. So the division has asked me to come in today and highlight a couple of items. The first is they want to make clear that the troopers would never enforce federal law, save a couple of very specific circumstances. So it's not the job of state law enforcement to enforce federal laws, nor civil federal laws. Having said that, I should at least note that we would assist federal agencies if they come across a state infraction while in the course of their duties. And we do that on a regular basis. We have a tremendous relationship with Border Patrol in our northernmost part of the state, and that is out of necessity. Very few law enforcement, very large piece of property to patrol and respond to crimes with. So we often have inner workings with our federal partners, but it is a delineated line that we stay on the state side of. Mr. Bissonnette talked about our fairness in policing policy. We do have that policy. I can make that policy available to the committee should that be requested. And what I want to say about that is just we worked extremely hard with lots and lots of partners to come up with that policy. We're proud of it. We stand by it. And again, if you so request, I'm happy to provide it for you. I did ask if this RSA, I asked of the Attorney General's office, will this RSA or will this proposed bill affect our policy? And the answer that I received was it's very difficult to tell. And they advised me to let the committee know that if you wanted to make an official request, they would certainly render an opinion. So having said that, thank you very much for the time this morning or this afternoon, and I'm happy to answer any questions you might have.
Thank you very much for your testimony, Major. Are there any questions from the committee?
Thank you again for the
Seeing none.
time.
Thank you. The chair will call Bob Dunn. Good afternoon, Mr. Dunn.
Good afternoon, Senator Carson, members of the committee. I'm Bob Dunn, the Director of Public Policy for the Roman Catholic Diocese of Manchester. And I'm here today on behalf of Bishop Peter Labashi to respectfully register our opposition to House Bill 1266. As you may know, immigration is a priority issue for the Catholic bishops of the United States. And it is undoubtedly an unbelievably complex issue and one that has a lot of rhetoric associated with it. The one point that I'd like to make today, I guess, is in deciding whether it is prudent to pass this bill, and prudence is the word that keeps going through my head here, I would ask you to keep in mind that I think that the bill was not, it was offered as a way of enhancing the public safety, but it wasn't offered by law enforcement as I understand it. There was no law enforcement agency that testified at the House hearing on this. And as a former Assistant Attorney General and former Assistant Commissioner of Safety, I can tell you that, and you probably know this yourselves, that state and local law enforcement in this state are very prepared to come forward and ask the legislature to put in legislation when they feel that it's something that is useful. And you've heard now from the state police, I understand that Chief Obecki from Hollis has sent a letter to the committee as well, talking about this bill and opposing the bill because of the fact that these agencies have really tried to address how this issue impacts people on the ground in those communities. And it's a really difficult balance because you've got the immigration laws and you've got the need to build trust and to have folks come forward in reporting crimes and work with law enforcement. And so in this particular case, it appears that at least the law enforcement folks that have come forward have indicated that that balance would indicate that public safety would best be served not by passing this bill, but by allowing them to continue with the practices that they've put into place already. And with that, I will conclude my testimony. Thank you.
Thank you very much for your testimony, Mr. Dunn. Are there any questions from the committee? Okay, seeing none. Thank you very much.
Thank you.
The chair will call Maggie Fogarty.
Madam Chair, members of the committee, thank you very much for this opportunity to speak. My name is Maggie Fogarty. I'm the New Hampshire Program Director for the American Friends Service Committee. And I have submitted testimony on behalf of the New Hampshire Immigrant Rights Network, so I won't read from that, but just to lift up 2 or 3 key points. The New Hampshire Immigrant Rights Network is a coalition of nonprofit agencies, faith communities, attorneys, people, immigrant community leaders, working together for humane immigration policies, primarily at the federal level, but also where those matters present themselves in local communities and at the state level. And we are in strong opposition to HB 1266. We assert that the passage of this bill would trigger civil rights and other legal concerns. We believe that HB 1266 is not good for New Hampshire, and it's anathema to the principles of equity and justice. We find it completely unnecessary, confusing, and vague. It appears to require state and local law enforcement organizations to engage in the enforcement of federal immigration law, and consequently may trigger exposure to significant liability. We also believe that laws like this prompt animus and suspicion toward New Hampshire residents who are perceived to be immigrants and may encourage racial and ethnic profiling. We also believe that a law such as this would compromise government-community relations, specifically as connected to law enforcement agencies. Immigration jurisprudence is carried out exclusively within the federal domain, mostly through the administrative civil law process. So there's no need for state laws or resources to be diverted toward immigration enforcement or to target immigrant communities. State and local governments already have obligations which are spelled out clearly in federal law to cooperate at key moments with federal law enforcement. This bill, however, appears to apply to all government employees within the state at every level of government, including even the judiciary. We want to note that bills modeled along these lines are promoted nationwide by an anti-immigrant organization called FAIR, an organization that was found by the Southern Poverty Law Center to be a hate group. So it's important to know the roots of this model of legislation. We want our cities and towns and their police departments to be able to make smart, sound, and just decisions that serve all of their residents. And we find this bill would do harm to those relationships. So we urge you to find it inexpedient to legislate. Thank you very much.
Thank you very much for your testimony. Are there any questions for Ms. Fogarty? Seeing none, thank you very much for your testimony. Are there any other members of the public that would like to speak to House Bill 1266? We can certainly have Representative Piemonte come back up so you can ask questions.
Just a simple 30 seconds.
Turn it again and turn your mic on. Thank you.
Thank you. Thanks for taking my question. Representative, just in simple terms, you don't have to pull any text or anything. What were you trying to do? Were you trying to say towns can't have sanctuary cities? Sum it up real easy what you're trying to do with the bill. Other people seem to be confused by your purpose. And was this your bill, or is this something from out of state, as people have suggested, coming from national sources? Or is this yours?
Thank you for the question. I took this bill from House Bill 266, the previous term. And there was, I would say, a good six, 7 pages in the bill. And I tried to, a constituent asked about the immigration. There was some discussion. And I tried to make it as easy and simple as possible, and I reduced it down to about two sentences, 1 paragraph. The second part of your question again?
Just your purpose. What were you trying to do? Was this your original bill?
Okay. So I clarified the part about the original bill, but the purpose was where we have our borders are just being crowded with people that we don't even know are here. And immigration is very, very, they have about 20,000 people to cover the whole state. So they're under a lot of strain. And with COVID, they were home, working from home. And they had no place where they could finish their job, basically. And there were cities and towns that did create policies that restricted them from doing their job. I'm not asking for the police to do the job. It's far from what I'm doing for here. It's allowing the immigration to just do their job without any prohibitions on them. That's basically it.
Quick follow-up? So you're trying to restrict, like, the term, colloquial term would be sanctuary cities? Is that what you're trying to do?
Pretty much, yes. And I think that that policy actually inhibits the immigration from the ICE people from doing their job. And I try to. Someone had mentioned profiling and things like that, and this bill specifically states that if you are arrested or for a crime, it has to be reasonable, to pick that person up and bring him to jail or hold them for any reason. And is not one to be questioned or, while in their possession of of any law enforcement. So it's not their position to question them or ask for their status, but if it's they have a detainer on it, it gives the police if the person's working, paying taxes, is here illegally, but he's doing his job, that's not the person they're looking for. If someone they find out is a major felony and stuff like that, then the police can use this detainer and go after him. So, and we have to protect our borders. There's no way that we know who is coming in with any reasonable semblance.
Thank you very much.
Are there any further questions? Seeing none, thank you, Representative.
Thank you.
Again, are there any other members of the public that would like to speak to House Bill 1266? Okay, seeing none, we'll close the public hearing. All these people want to see. Are you all set, Jen? Is there something wrong? I'm sorry? Yeah, he's representing Bert today. We're going to go ahead and open the public hearing on House Bill 1178 and recognize Representative Lind, who is pinch hitting today for Representative Burt, who couldn't be here. Good afternoon, Representative Lind.
Thank you, Madam Chair and members of the committee. Representative Burt, the prime sponsor of this bill, apologizes for not being here. He is currently appearing before another Senate committee in support of another bill of which he also is the prime sponsor, and he asked me to introduce the bill as one of its co-sponsors. We are fortunate to live in a state that strongly supports the right to keep and bear arms. Unfortunately, at the federal level, the current administration has a very different view of the Second Amendment. It has proposed, both through legislation and even more troubling through unilateral regulatory actions, measures that significantly undermine the rights of law-abiding citizens to own and use firearms for self-defense, sport shooting, and other lawful purposes. Excuse me. Collectively, the net effect of these proposals is to emasculate the Second Amendment through death by 1,000 cuts. HB 1178 is designed to ensure that New Hampshire never becomes complicit in that strategy. This bill is almost identical to a bill, Senate Bill 154, that was passed by both the House and the Senate last year. Because there was some difference in language between the House and the Senate versions of the bill regarding Section 2 of that bill, it went to a committee of conference. And although the committee came to an agreement, the agreement didn't satisfy some House members, and so the bill was ultimately tabled. I am very happy to report that the differences that scuttled last year's bill have been resolved in the current version, which passed the House with a solid vote and bipartisan support. The provisions of the bill are simple and straightforward. Section 1 of the bill says that no personnel or financial resources of this state or its political subdivisions shall be used to enforce, administer, or cooperate with the federal government in the enforcement or administration of any federal law, regulation, or executive order regarding the regulation of firearms, ammunition, firearms, components, etc., that is inconsistent with New Hampshire law regarding the same subject matter. Because, as in most states, New Hampshire law enforcement has a long history of cooperating with federal authorities in many areas of mutual interest. Section 2 of the bill makes it clear that the prohibition in Section 1, the prohibitions in Section 1 do not apply when federal authorities are investigating someone as to whom there is reasonable suspicion to believe that that person has committed a violation of state law or a violation of federal law that is not subject to Section 1. Section 2 also allows state authorities to provide their federal counterparts with publicly available information, criminal history information, or information needed to fulfill New Hampshire's responsibilities under the National Crime Prevention and Privacy Compact. Under the leadership of Representatives Abbas and Burke, the Criminal Justice Committee in the House worked hard to achieve consensus on this legislation among various stakeholders. It includes provisions suggested by the New Hampshire Attorney General and by the NRA and Gun Owners of America, all of whom have reviewed the bill's language and are on board with it. I respectfully ask that you recommend this bill as ought to pass. I'm happy to answer any questions you may have.
Thank you very much for your testimony, Representative. Are there any questions? Senator French.
Thank you. Does this take away federal statutes?
Not at all, not at all, not at all.
So actually, what does it affect?
Well, it says that if there are differences between federal, in other words, if federal law, for example, prohibits something that New Hampshire law does not, then and the only investigation is relating to that federal law that is inconsistent with New Hampshire law, then no state resources can be used in the enforcement of that.
Yep, go ahead.
So if we had no laws in the state of New Hampshire regulating guns,
Right.
then there would be no laws regulating guns in the state of New Hampshire.
If there were no laws, if there were no state laws regulating guns, what this, and of course there are, but if there weren't, this would mean that if the feds, let's say there weren't a state law that prohibited a felon being in possession of a gun. Yeah. Obviously there is a state law, but let's assume there wasn't. But there is a federal law that prohibited that, which there is. This would say that the federal government through ATF or whatever can enforce that law, but no state resources could be used to enforce that federal law.
Okay, thank you.
Are there any further questions for Representative Lynn? Okay. Seeing none, thank you very much,
Thank you.
Representative. The chair will call Richard Head. Good afternoon, Mr. Head.
Good afternoon, Madam Chair, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. What is being handed out is a requested amendment, and I apologize for coming in a little bit late with the amendment. The amendment, so looking at the bill, lines 9 through 13, skipping some words, says that the state of New Hampshire shall be prohibited from using any personnel or financial resources to enforce, administer any law, act, rule, order, or regulation of the United States government that is inconsistent with any law of this state regarding regulation of firearms. That part of it doesn't sort of give me the concern that gives rise to the proposed amendment. Lines 15 to 16 say that silence in the New Hampshire revised statutes annotated pertaining to a matter regulated by federal law shall be construed as an inconsistency for the purposes of this chapter. And so it was brought to my attention that the domestic violence registry may conflict with that second part, where there are some aspects of what the domestic violence registry does are in accordance with court rule and domestic violence protocols, but may not be specifically articulated in the RSAs. So although I can't say for certain that it is inconsistent, but it at least raises an ambiguity that we are hoping through this amendment would clarify the role of the domestic violence registry when there is no state prohibitor involved, but perhaps a federal prohibitor involved. So, for example, if a final stalking order is issued, it does not have a weapons prohibition in it, the domestic violence registry would still record that into the federal databases and would say perhaps a Brady unknown or unknown federal prohibitor. It's not 100% clear as to whether or not that would be inconsistent with the line in the statute about silence being inconsistency. So we are asking that the line that's on the second page of what I handed out in red that gets added to the end of the main paragraph that says nothing in this chapter shall prohibit the judicial branch from entering protective order information into law enforcement databases. And we think that would clarify the ambiguity, and we don't think the intent of this bill was to prevent the registry from loading the information about protective orders into the database. And with that, I would conclude my comments, but would be happy to answer any questions.
Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none, thank you very much.
Thank you.
Okay, the chair will call Eric Granger. Good afternoon, Mr. Granger.
My name is Eric Granger. I'm over in Milton Mills, New Hampshire. And I'm also going to be talking about why gun owners in New Hampshire and across the country are very confused. And it has to do with why the ATF's rules and regulations and how they interpret written law in creative ways in order to cause us headaches. So hundreds of Granite Staters are likely accidental felons. It is extremely easy to accidentally break federal gun laws or federal gun rules, or at least the ATF's interpretations of those rules. I am not a lawyer, and most gun owners in the state of New Hampshire are not lawyers. We shouldn't be expected to have legal degrees in order to understand the constantly changing rules and the creative interpretations of federal laws. And I have a couple examples in here. So for instance, if you look at the picture of the ATF agent, you'll notice that he's using two hands to fire a handgun. US code states that a handgun is meant to be fired with one hand. However, the ATF will determine that any pistol that has a vertical hand grip located on it is meant to be fired with two hands and therefore is illegal. However, if you have an angled foregrip, so if you hold it like that instead of like that, that's totally okay. That they've released letters, and I have a section in here with an excerpt from one of those letters where they clarify that yes, an angled foregrip is okay, a vertical foregrip is bad. If we can't tell the difference, if we have a hard time determining what the actual rules are, people are just going to break them on accident, and then they'll go to jail. So that's not, that's not good. Question, is this a shotgun? It looks like a shotgun. It acts like a shotgun. It looks like a sawed-off shotgun, but it is not, because it is 26 inches or longer, and it never had a stock, and it doesn't have a rifled barrel. So legally, it is not a shotgun. However, this is a shotgun, because it did have a stock at one point. There is no functional difference between those two firearms. Anybody who just happens to see somebody at a range using a Mossberg Shockwave might think, okay, well, that's kind of cool. What if I did that to my shotgun? And then they cut it off, and then they become a felon, purely by happenstance, purely on accident. They don't know any better. This happens very frequently. We also are dealing, whether it's this administration or previous federal administrations, they create rules just by making them up. So for instance, during the Trump administration, they decided bump stocks were machine guns. And the ATF released guidance that everybody had to turn in their bump stocks or destroy them. And then they went to court and they lost. And then they determined that bump stocks are not machine guns. And those people didn't have their bump stocks undestroyed. They didn't get their bump stocks back. They're just gone now. The same is true for, I got several examples here anyway. Is a shoelace a machine gun? The ATF says that yes, it is. If it's used in a certain way, a shoelace is in fact a machine gun. Same is true for bent coat hangers or metal cards with a picture painted on it. You're probably going to hear other people talk today about ghost guns, which are home manufactured firearms. And that used to just be a home manufactured firearms, but now they call them ghost guns, and they're making up new rules as they go. And there's still questions that we have is, okay, do we have to serialize our upper receivers now? Do we have to serialize existing homemade firearms? What about people who don't know and didn't get the memo on this, and they just happen to have Grandpa's old hot gun that he made back in the 70s? Do they have to serialize it now? What if they didn't get the memo? Are they going to become felons on accident? And it would be really nice if police in the state of New Hampshire didn't play along with this. It's unreasonable to expect them to, if we can't understand the rules, they're probably not going to understand the rules either. And you're going to save a lot of people a lot of headache for really victimless nonsense rules that the ATF just makes up if we just don't enforce this at the state level. I also do not think that we should have the amendment. The amendment totally defeats the purpose of the bill. And the amendment will completely make it toothless and give the police any right to just do whatever and to cooperate with the ATF all they want. I would really like this to pass without the amendment. And yeah, I'm available for any questions. Thank you for your time.
Thank you very much for your testimony this afternoon, Mr. Granger. Are there any questions from the committee? Okay, seeing none, thank you very much. The chair will call Daniel Koenig. Good afternoon.
Hello. My name is Daniel Koenig. Koenig is fine. You aren't the first one to have that reading, and I appreciate the opportunity to be here. I'm a resident of Brookline and represent myself and my family. I'm testifying in support of the bill and advocating for the removal of the House amendment, which is now Section 2, the second paragraph in the bill. To support the bill, you've heard that enforcement of federal firearms law is increasingly complex and prone to error. This, as a result, is a financial and a moral liability to our state and municipal law enforcement and to Granite Staters on the whole. And I'm going to address both the financial and moral liabilities there. One example of the financial liability, in 2018, police were called on a domestic disturbance to a man named Kellen Wright, a black combat veteran who works with the VA now, helping other black combat veterans. As part of the process, they removed the firearms from his home, and later, those firearms made their way to the ATF, who inspected them and found that one of them was an illegal, unregistered short-barrel rifle on the basis that the length of pull on the gun was greater than 13.5 inches. Notable in this is that the local law enforcement at the scene felt that they required the ATF's eyes on these to even be able to determine the legality of these guns. If that's the case, I think, to echo what Eric said, that it's unreasonable a little bit for us to expect the average citizen to. Length of pull is a technical term referring to distance between the trigger and the back of the gun, like that. The ATF says that if a length of pull on a gun is greater than 13.5 inches, that this is a rifle. They say this only in private communication. They've never published it or publicly published it, but there's internal policies that say this. In trial, it was discovered that unlike previous investigations, they had measured the length of pull not straight back from the trigger to the back, but at a diagonal as if you were to measure the width of a piece of paper, not along the edge, but at a diagonal from the corner to the other corner like that. When it was properly measured, the way they had previously done it, in every investigation before that, they found the length of pole was less than 13.5 inches. Mr. Wright was acquitted, but not before 7 months of trial at great cost to himself, great cost to the investigators, the state, the courts, the public defender, and so on and so forth, over something that's, trivially silly, patently silly. There's a moral liability as well to this, and let me give just 2 examples of that. In 2013, the ATF ran a sting operation to catch people illegally transferring firearms. They arrested and charged Alexis Davis, who was an intellectually disabled black man. He went to trial and was later acquitted on the basis that the ATF had taken advantage of his intellectual disability and defended himself, claiming entrapment successfully. I have a son with physical and intellectual disabilities. As if that's not hard enough for him and for us, is he now at risk for being targeted by a federal agency with the assistance of New Hampshire State Police on bogus charges so that they can make arrests? As a second example of moral liability, in June, the ATF is set to revise rules related to pistol braces, which are devices used to stabilize a pistol against the forearm and which were invented to allow disabled combat veterans to enjoy recreational shooting. The ATF has previously officially approved various designs for these braces, but the new rules are set to reverse those approvals and will make some braces in some configurations now illegal unregistered short-barreled rifles. The penalty for ownership of one of these is 10 years in prison. It's an abomination to approve pistol braces used by disabled people and then later to target them and accuse them of crimes for continuing to own and use those items. My family owns pistol braces. I have a disabled son. Will we be charged and put in jail because we own these items? Items that were specifically approved by the ATF and used in configurations that are currently legal. Law enforcement in New Hampshire has a reputation for honor, integrity, and justice. To participate in enforcement of federal firearms laws is a violation of those and is to sell their birthright for a mess of pottage. Regarding the amendment added by the House, which is Section 2, it was added after testimony that cooperative law enforcement efforts between state and federal agencies, such as at drug busts, sometimes end up involving firearms, and there was uncertainty about how this bill would affect these efforts. The amendment would exclude from the protections of the bill any person for whom there is a reasonable suspicion that they have ever committed any violation of law. It doesn't say criminal law. There's any law, order, any, I think there's a few other phrases there. This means anyone who's ever gone 56 miles an hour in a 55-mile-an-hour zone, anyone who took their mask off at an airport once, anyone who's applied pesticides to their home garden without reading the label first and so on would be excluded from protections of this bill. It's a little absurd that the remedy to one specific point of uncertainty is to broadly neuter the bill and exempt virtually the entire population from its protections. This is not the quality of legislation the New Hampshire General Court has historically produced. Let me also list a couple of alternatives. 1, let law enforcement consult with their legal counsel before these cooperative efforts. That's what they're here for. Let the federal government provide staff if they want federal gun laws enforced during unrelated drug stings. If someone's arrested for drug crimes, their illegal guns present no immediate danger. That can't wait for a federal agent to arrive. Let the courts decide the issue. That's why we have courts. If the choice is we have to accept a couple of lost cases versus the weight of excluding virtually the entire population from the protections of this bill, to me, the lost cases is an easy win. Let the Attorney General decide. And finally, there's no enforcement of the prohibition on this for law enforcement officers who find themselves on the other side of the law. So it's not as if we're putting law enforcement officers personally at risk. To craft legislation around how law enforcement would like to do it is sort of backwards of what it ought to be. So for that reason, I'm urging you, the bill ought to pass. Amendment, which is now Section 2, should be removed. Thank you.
Thank you very much for your testimony.
I'll take questions if there are any.
Thank you. Are there any questions from the committee? Seeing none, thank you very much for your testimony. The chair will call Milo Marate. Good afternoon.
Good afternoon. My name is Milo Marate. I'm from Salem, New Hampshire, representing myself. Thank you for this opportunity to testify in support of this bill and for, as others have explained, removal of the House Amendment, paragraph E2. Enforcement of federal gun laws in this state, the status quo, takes legislative authority practically out of the hands of the people and this general court and surrenders it to the federal government. It's a failure to exercise our rights under the 10th Amendment and the anti-commandeering doctrine. federal government changes their laws and rules at will, as others have explained before me. One notable example is pistol braces. The ATF in June will be adding 26 pages, very small print, of rules just dealing with pistol stabilizing braces. Particularly audacious of them, considering they've been without an appointed director since 2015, and before that from 2006 to 2011. New Hampshire law enforcement has to keep up with these ever-changing rules from federal agencies. It gives an increasing amount of authority to those agencies, minimizing the role of state and local lawmakers to direct state and local resources. By passing this bill and removing that House amendment, we can keep control of state and local legislative authority and law enforcement at the state and local level where it belongs. This is a key tenet of political thought in New Hampshire and is worth preserving. Thank you. No questions, please.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you very much. The chair will call Zephan Wood. Good afternoon, Mr. Wood.
Hi, good afternoon. So my name is Zephan. I'm a citizen, taxpayer, homeowner, small business owner, and active participant in my community here in New Hampshire. I am here to voice my strong support for HB 1178. This is arguably one of the most important bills that will be voted on this legislative session. HB 1178 in its best form, the original form before the amendment, enshrines the individual right to keep and bear arms in the state of New Hampshire by preventing the federal government from enforcing tyrannical and overreaching gun control measures. As history has shown us, whenever a populace is disarmed, dire consequences ensue. In fact, democide, a term coined by Rudolf Rummel, meaning death by government, was one of the leading causes of death in the 20th century. More specifically, it was responsible for roughly 262 million deaths in just the 20th century. And one of the first pieces of legislation that's generally passed in these countries that seek democide include restrictions on the right to keep and bear arms to make the populace docile and easier to control. Furthermore, according to a report conducted by the CDC under the Obama administration, if you'd believe it, firearms are utilized defensively anywhere from 500,000 to 3 million times per year in the United States alone. Additionally, Granite Staters have a long and proud tradition of independence, self-reliance, and self-defense, and passing this will ensure that that culture, history, and that integral part of the Granite State is preserved. By stopping the federal government in overreaching into the state, we will preserve the liberty and freedom that is the pride and glory of New Hampshire. Furthermore, I move this bill be passed OTP without the amendment added in the House, as it severely waters down the bill and mostly makes it a symbolic measure. The best way to protect Granite Staters' inherent right to self-preservation is to pass the bill without the amendment. That being said, this bill still represents a significant cultural victory, demonstrating that New Hampshire will defend Granite Staters from federal tyranny in respect to gun control, and is absolutely crucial. So please support OTP of House Bill 1178 and remove the amendment made in the House. Thank you.
Thank you very much for your testimony this afternoon. Are there any questions from the committee? Seeing none, thank you.
Thank you.
The chair will call Gabe Holdren. Good afternoon, Mr. Holdren.
Good afternoon. Grateful for a chance to speak on the subject. And while there seems to be an amendment that does hedge between the two, there are basically two paths that you have to choose here. Now, if you go down one path, you can protect the rights that the people of New Hampshire have. And if you go down that path, we'll have peace. And that's really what I want more than anything. And I'm begging you to choose that path. Because I got to tell you, the other path is not worth imagining. We have seen the federal government move forward more and more every year, overstepping their bounds on taking the right to the property that the people have. And one day, the people will not stand for it. And you can either be standing with the people against those who are encroaching on their rights and causing them to rethink their position, or we can find out exactly how far the people will be pushed. And I never want to see that day. We still have this chance to avert disaster, but we are very, very close to it. So I urge you, please, and if possible, without the amendment watering it down, to pass this, bring it to the ought to pass, so that we can keep the peace in this beautiful state. Thank you.
Thank you very much for your testimony, Mr. Holdren. Are there any questions from the committee? Okay, seeing none, thank you. The chair will call Nick Hubbard.
Good afternoon, Senators. My name is Nick Hubbard. I'm a resident of Somersworth, New Hampshire. Wanted to testify in support of House Bill 1178 because all federal laws restricting the ownership, transfer, or use of firearms are infringements on our fundamental rights. And I believe that House Bill 1178 ought to pass, as it would serve as an important safeguard against existing and future encroachment on those rights. I also share the concern voiced by others present today about Section 2 of the proposed new Chapter 159E, in which it would be included, and whether it could be used to undermine the intent of the legislation as a whole. The federal criminal code is large enough that the Congressional Research Service, the U.S. Justice Department, and the American Bar Association are unable to give an accurate count of possible offenses that could exist under the code. And my concern is that federal law enforcement might deliberately make malicious use of Section 2 of the new chapter in order to target granite staters for exercising their gun rights by using any excuse they could dream up to compel our police to cooperate with them in acting against our interests. And I understand that this language was added and included in order to enable our police to carry out their duties as effectively as possible, and ensure the safety of New Hampshire residents. And even though I don't think the language is perfect, I still feel that the bill ought to be passed and that it could be refined at a later time. Thank you.
Thank you very much for your testimony. Are there any questions? Senator French has a question?
Yes.
Yeah, thank you.
Yes.
Thank you. Thank you for testifying today. You hit upon it real briefly there. So have you done research on the amount of federal law, rules, regulations on firearms versus state law? Have you done a side-by-side comparison?
No, I haven't.
You haven't, okay, because you did touch that the federal law was much, much larger than what the New Hampshire law is, correct? Or you assume that?
Well, I wasn't talking about firearm law specifically, but just about the size of the federal legal code as a whole, and that its size and complexity, given that Section 2 of the proposed new chapter would require New Hampshire police to cooperate with federal agents with cases that weren't directly related to firearms use, but which could be related to any other violation of federal law, that it could be used as a sort of backdoor to get around the protections intended by New Hampshire's, by HB 1178.
Okay, I didn't know if you were an expert on it, so.
I'm not, I'm just a layperson.
Okay, thanks.
Are there any further questions from Mr. Hubbard? It's seeing none. Thank you very much. The chair will call Victor Muzzy.
Thank you, Madam Chair.
Good afternoon, Mr. Muzzy.
Good afternoon, members of the committee. My name is Victor Muzzy. I'm a captain with the New Hampshire State Police in charge of the Justice Information Bureau, which for the purposes of today's hearing includes the Permits and Licensing Unit. As I'm sure members of the committee are aware, the state police operates a gun line in which we perform checks on the purchases of handgun purchases throughout the state. Our concern with the way the bill is written is the implication that that may have on that operation, what's expected of us as a result of the legislation, or any unintended consequences that may fall from this legislation. I think seeking more clarity on what our role may be, or how that may be affected, I think is my purpose here today, just to inquire about whether or not the committee has considered what that operating change may be for us should this bill pass. That's my testimony. I'm open for any questions or any discussion.
Thank you very much for your testimony. Are there any questions from the committee? Senator Whitley.
Thank you, Madam Chair, and thank you for being here, because I think you hit on some concerns that were raised before. I know the judicial branch passed out an amendment, but the concern is that since only public records and criminal history records can be reported by state officials to the federal authorities, doesn't that mean that civil records, like for those for domestic violence, restraining orders, or, related to involuntary mental health commitments, both of which prohibit firearm ownership under federal law, doesn't that impact, under this law or under this bill, that means that those wouldn't be able to be shared with federal authorities. Isn't that correct?
That would be my understanding.
Yeah. So follow up. Thank you. And so wouldn't that mean that, this bill would make it easier for those people who, have been found to be violent domestic abusers or, a serious mental, wouldn't that make it easier for them to get access to firearms?
I suppose it could, and that's a concern of the legislation and how deep the explanation is, or the intent is.
Yeah. Thank you. Are there any further questions? Senator Khan, and then Senator Gannon.
Thank you, Madam Chair. I want to ask you about ghost guns. This has been a concern that recent news, easy to pick up on for someone like me. And does New Hampshire have any laws on a do-it-yourself gun?
To manufacture your own? Not that I'm aware of.
And so it would be only through the use of a federal law that
based upon their definition, I suppose.
Confiscation of those goods from which a ghost gun, an unregistered gun, could be produced.
Correct, based upon the federal definition or regulation.
Thank you.
Are there any further, Senator Gannon and then Senator French?
I appreciate your concern with the gun line, but if you look at line 13, where it's talking about inconsistent with the law of the state, isn't the gun line consistent? So I don't think you'd have a problem based on my reading of this bill.
That's fine, and that's our hope, I think, ultimately, but it doesn't delineate that necessarily. I think it is consistent, but I think it might be an unintended consequence potentially on how this is passed or how it's written. It doesn't clearly delineate that practice and that operation is still authorized under this proposal.
But you understand, so I'm saying it's consistent, so I don't see that as a problem for you.
I do.
Okay, thank you.
Senator French.
Thanks, Madam Chair. Thank you. Getting back to the question of ghost guns, isn't a ghost gun just a gun that's manufactured by an individual that they didn't stamp a serial number into?
That's my understanding.
So if I made a gun and I stamped in the receiver number 1, that would be not a ghost gun. And then stamp number 2 in the next one I made, and number 3 in the next. What's the big difference?
The ability to identify it, I think.
For who?
Or differentiate it. I suppose law enforcement.
Okay, but it's still a gun, and it'd be not considered a ghost gun if I stamped it with
an identifying
numeral
mark.
1.
Correct.
Okay, thanks.
Okay, are there any further questions? Senator Whitley.
Thank you, Madam Chair. Thank you for taking another question. there's a lot of facets of this bill that we really do need to understand, and those unintended consequences, I think, are really important to understand. Because we're talking about, federal law, enforcement of federal law, are there any sort of federal grants, federal programs that we would be, losing out on or missing out if we're not cooperating with the federal authorities as we're required to do?
I'm sure there are. What those may be in front of me today, I can't answer that question adequately, but.
Okay, thanks.
Are there any further questions from the committee? Senator Khan?
Yeah. And along that line, and thanks for taking
Yes, sir.
questions, but I think understanding your perspective on this bill is an important one. Yeah, we're somebody from your department, you're here. Does the department receive any kind of grants for enforcement?
For the enforcement of firearms laws, no, not at the moment, no. That doesn't mean there aren't some other federal grants that may somehow be connected to that, but again, I can't answer that question, but we don't have any funds, to my knowledge, that we're receiving that are directly tied to enforcing federal gun law.
Yeah, I mean, my reason for wanting to ask is does the enactment of this perhaps run counter then to the state's ability to receive funding for enforcement?
Again, I don't know that I'm adequately prepared to answer that question, but I would say if the money is specifically tied to the enforcement or assistance in enforcing any federal law, then yes, I would say this bill would be prohibitive to that cause.
And may I ask one last one?
By all means.
Would it be the Department of Justice that receives
It very well could be.
if there's somebody from
In most
Department of
cases,
Justice
in my
that has that?
experience, it has been.
Thank you.
Senator Whitley?
Thank you, Madam Chair. Again, thank you for indulging us in all these
Yes.
questions. I think, this is particularly in this area of this ghost gun. I know this has been in the news a lot. This is a sort of new area that we're trying to figure out, right, about how to keep people safe, because we do know that these ghost guns, these kits are being used more often, is my understanding. So, because there's been an update, as you may be aware, with the federal law that says that, even just these, dangerous parts, can be treated like finished firearms if they're found. These are federal laws. So, I'm thinking about a situation where New Hampshire authorities, there was a firearms trafficker in New Hampshire that was caught, and in the trunk there were unfinished frames, there were certain things, but not the finished products, right? So under this, if this bill passed even as is, even with the House amendment, you wouldn't be able to do anything, correct?
Correct.
Okay. And last follow-up.
Yes.
So that means that gun traffickers, if I was a gun trafficker, wouldn't you want to go to a state where where our local authorities had, no jurisdiction to stop you?
Assumingly.
Thank you.
Okay. Are there any further questions from the committee? Okay, seeing none. Thank you very much for your testimony.
Thank you.
The chair will call Elliot Axelman. Good afternoon, Mr. Axelman.
Good afternoon. Thank you, Senators. My name is Elliot Axelman. I live with my wife in Hooksett, New Hampshire. I'm representing myself today. Quickly before my remarks, I'll address the two things I believe the police officer said. As far as the concern with ghost guns, I know it's been in the media a lot recently. I've seen the ATF or Biden plans to make some executive order about ghost guns, I think. I have here, according to WashingtonTimes.com, I'll send this to the committee later. They account for very, very, very few crimes committed with guns. Not even crimes. The statistics we have here are confiscations of firearms. in cities like Chicago where firearms are essentially illegal. In Chicago, of the 11,200 firearms seized, only 139, or 1.2%, were ghost guns. In Philadelphia, 2.2% of the 4,000 firearms seized were in 2019 were ghost guns. So again, and that's not even crimes. I would venture to say maybe 1 in 5, 10, 50,000, 100,000, 1 in a million crimes are committed by those with ghost guns. Most are bought on black market or legally, or found or traded or borrowed or bought from a friend. The other point I believe Senator Gannon made, I was going to make, was the state police officers seemed to insinuate an interesting point that the state gun line, if they might not be able to operate it if this bill passes, and the state police and local police can't assist federal law enforcement with gun control, but the bill only says we can assist them with things that violate state law. And I know the New Hampshire gun line doesn't violate state law because it's called the New Hampshire gun line, so it doesn't violate state law. Now, on to my quick remarks. There are 3 big reasons, I believe, 3 massive different reasons why there should not be any gun control. Thankfully, New Hampshire has the most overall freedom for firearms in the United States, which makes me extremely proud to be in Live Free Die state. We should not pass gun control, and the legislature has consistently for the last few years, decades, rejected efforts to enact gun control, thankfully, in fact, expanded gun freedom, which is great. I'll also point out that it's a natural right. The first big reason is the Constitution. The Constitution says it shall not be infringed. And I just thought of it for the first time a few weeks ago. A lot of people believe that the Constitution says shall not be infringed, the right to keep and bear arms, that the founders were very stupid and didn't understand how qualifiers, didn't understand that they could say, but it can be infringed in certain areas. If the founders were smarter, if they were as smart as we are nowadays, they would have said it can be infringed if the government feels that it's best for safety or for any other reasons, or think of the children or the safety or any reason they want to infringe on it. There are no qualifiers. What I realized in studying constitutional law now in pre-law is in the 4th Amendment and the 5th Amendment, I believe there are qualifiers. It says they shall not search or seize anything but upon probable cause with a warrant. In the 5th Amendment, I believe, eminent domain, it says they shall not seize property unless they justly compensate the person, then they can. So the founders were not, in fact, that stupid. They actually understood you could have qualifiers. They understood you can say, but there are exceptions to this total concrete rule. So if they would have believed in any gun control, they would have said, the right to keep and bear arms shall not be infringed unless the government believes that it's best for safety or any other qualifier. So the fact that they did not include that is all the proof we need. In fact, there's tons more proof from the Federalist Papers and other documents written by all the founders involved in the Constitution, the Revolution, the founding, the Federalist Papers that I'll send later on with my testimony as well, proving beyond a shadow of a doubt the founders wanted zero gun control. They wanted the citizens to have at least as much power, military power, all arms, all weapons, as the government, as much or more than the government. But that's not even the best reason. I think the constitutional reason is the weakest of the 3 big reasons to oppose gun control, to be honest. The second big reason is natural rights. The right to keep and bear arms is a natural right. It includes 2 natural rights, actually. Every human being and every animal, and I think organisms like plants, every organism in the world has a natural right to self-defense. You see, the plants actually snap and they kill the insects when they attack them or they lay eggs on them. So even plants have this, but animals, obviously zebras have a right to self-defense from lions. Every animal has a natural right to self-defense. Humans sure do, definitely even more. So it's a natural right to self-defense. Also, gun control people rarely talk about violates another natural right, the right to property. We all have a natural right, again, not given to us by politicians. This right was not given to me by Biden or Trump or anyone. It's a natural right to have as a human. The government sometimes violates that right, which is, not a good thing, but it's a natural right. We have a natural right to own property. I have a natural right as a human being, born as a human being, if you believe it's God-given or natural, whatever you believe. Personally, I'm pretty agnostic. But I believe every human being has a right to own property, even if that property is made of polymer and steel, even if that property is a tool that can fire a projectile. We all own property that's dangerous. I own a Ford Fusion. It weighs a few thousand pounds, and it's very dangerous. It can kill and has killed 30,000 people a year. It's very dangerous. It is. It's also a tool that's productive. So we can own property even if it's made of metal and plastic like my car, or polymer and steel like firearms. It's a natural right to own property. So I think the human rights, the natural rights of self-defense and own property is the biggest reason why all gun control should be thoroughly rejected. The third reason, if you're not into the Constitution or into the ethics of human rights, then another reason everyone should oppose gun control is practicality. Practically speaking, does it work? I'll send tons of evidence. I've written many articles about it. gun control does not work. I'll send it to the committee later. If you look at all this, the cities and all the states, if you break it down by city, county, area, state, or laws throughout the United States, you can see almost a 100% perfect correlation, a direct correlation between the strictness of gun control, like New York City, which has the strictest gun control, which I lived in for 10 years and thankfully escaped here, the strictest gun control and among the highest murder rates. Baltimore, among the strictest gun control, the highest murder rates. Chicago, among the strictest gun control, the highest murder rates, or second highest murder rates, I believe. So there's almost a clear correlation that we have New Hampshire with no gun laws, Wyoming, no gun laws, and Vermont and Maine, essentially zero gun control, and consistently the safest states. Every single year, if you look at homicide, violent crime, and gun crime, New Hampshire, Maine, Wyoming, and Vermont, I believe, are the top four. They switch around places every single year, safest. So, and I think I only had one or two more points. Please get rid of the amendment from the House. The House amendment neuters the bill. It says none of this applies if there's any potential investigation into anything, meaning this doesn't really apply. So the House amendment, unfortunately, would make the bill ineffective. So if the amendment can't be erased, I would rather just kill the bill because the bill does nothing. It would be a waste of time and paperwork for everyone. So please pass this. I don't know if you call it OTPA, but please strike the House amendment and pass it. In fact, I would, in my dreams, even like an amendment even stronger to not allow state enforcement, but also prohibit federal enforcement of gun laws in the state. For instance, if a ATF agent came in, which happened a few months ago and happens sometimes in New Hampshire, as they mentioned, there are probably thousands of pages. There are ridiculous amounts of laws where the ATF arbitrarily says anything that can increase the rate of fire for anything is a machine gun. So they essentially redefined anything that can increase rate of fire as a machine gun. Even a piece of plastic that weighs 1 ounce, they call that a machine gun, and you can go to prison, I think, for decades for that. So the ATF shouldn't be enforcing laws here. Ideally, even ATF agents should politely be asked by our state police to leave and not enforce it. And, you know, I would like that amendment in the bill as well. But I think the important thing is to get rid of the House amendment and pass it as originally written, and then hopefully Committee of Conference can settle the score there. Thank you very much. I'm happy to take questions.
Thank you very much for your testimony. Are there any questions from the committee? Senator French?
No.
Okay, just want to make sure. Okay, seeing none, thank you very much for your
Thank you very
testimony, Mr. Axelman. The chair will call Zandra Rice Hawkins. Good afternoon.
Good afternoon. My name is Xander Rice Hawkins. I'm the director of Gun Sense New Hampshire project to grant state progress. I'm here today to testify in opposition to House Bill 1178. Let's be really honest about this bill. This isn't about protecting Second Amendment rights. It's about preserving the corporate gun lobby's ability to increase profits off the murder of American families. Gun deaths and mass shootings fill our news cycle each week, and we shake our heads, and some have the audacity to offer thoughts and prayers instead of concrete action. Now the Biden administration and leaders in Congress are working urgently to save lives. And the response by some New Hampshire politicians is to find ways to block, stop, or delay those efforts, even though it will cost lives. And even though we should all be able to agree that our families shouldn't have to live in fear of going to the grocery store, or to work, or to school, or to the movie theater, or to a health clinic, or a bowling alley, or walking down in the street in our community, or playing in the park, or living in our homes, because dangerous individuals can easily access firearms and shoot and kill our families. Let's set aside for the moment that House Bill 1178 is likely unconstitutional and could cause New Hampshire to lose hundreds of thousands of dollars in federal grants and aid, and that it is completely absurd to block public safety laws. Let's review some of the common sense public safety rules that the sponsors of this bill amendment want to stop. The Biden-Harris administration announced several actions last year related to firearms. They directed the Justice Department to issue a proposed rule to help stop the proliferation of ghost guns. As more criminals buy kits to assemble firearms in as little as 30 minutes to commit crimes that cannot be traced to the weapon, proposed rules like this will help stop the proliferation of these firearms. A proposed rule to make clear that devices marketed as a stabilizing brace are subject to the National Firearms Act. Stabilizing braces are popular accessories intended to increase the accuracy of AR-15 style pistols and allow users to fire them much like their rifle counterparts. The Boulder gunman had recently purchased an AR-556 with a stabilizing brace. This rule makes it clear they are subject to the requirements of the National Firearms Act. The Justice Department should publish model red flag legislation for states. This will make it easier for states to adopt red flag laws, which let family members or law enforcement petition for a court to order temporarily barring people in crisis from accessing firearms if they present a danger to themselves or others. These are the types of measures that we always hear would have been helpful before a mass shooting. The Justice Department will issue an annual report on firearms trafficking. They're to issue a new comprehensive report, which hasn't been done since 2000, and annual updates necessary to give policymakers the information they need to help address firearms trafficking today. New Hampshire is a net exporter of crime guns. And the administration is investing in substantive, evidence-based community violence interventions, proven strategies for reducing gun violence. They directed 5 federal agencies to modify 26 programs that will route vital support to community violence intervention programs. House Bill 1178 would jeopardize the public safety in other ways, preventing state work with ATF, DOJ, and the FBI. It prohibits state and local police, judges, prosecutors, and others from enforcing, administering, or cooperating with any federal law, act, rules, orders, or regulations if the state of New Hampshire doesn't have those same laws in place. The House amendment does nothing to ease these concerns. Instead, it continues to sow confusion and actually encourages criminal activity by sending the message that federal gun laws will not be enforced. The House carve-out is explicit that cooperation applies only in narrow situations where a person has also committed, is committing, or is about to commit a violation of a New Hampshire law or a violation of a federal law not related to firearms. Any area where New Hampshire law is silent, such as in background checks or possession of firearms by convicted domestic abusers or the proliferation of ghost guns, would be deemed inconsistent and not enforced. If passed and signed into law, under Governor Sununu and this state legislature, New Hampshire would become a haven for criminals trying to skirt federal public safety laws. This version of the bill, like last year's failed amended version, also does not provide any start date for the application to new presidential executive orders or federal laws and regulations, so it appears to apply to federal laws and regulations already on the books. Do we honestly know how this is going to play out? How would this impact any arrests or sentences in our state? And could it result in appeals that lead to convicted criminals being released? You've already heard today about one problem that's been identified around domestic violence. I'll say that this amendment doesn't even cover the other part of that. New Hampshire law prohibits a defendant subject to domestic violence protective order from purchasing or possessing firearms and ammunition for the duration of the order. However, New Hampshire law, unlike federal law, does not prohibit individuals convicted of domestic violence misdemeanors from purchasing or possessing firearms or ammunition. Granite Staters strongly support common sense gun safety laws. Bills like this one hold us back. They harm our community. House Bill 1178 is inappropriate in any form, and we urge you to recommend it and expedient to legislate. Thank you.
Thank you very much for your testimony. Are there any questions from the committee? Senator Whitley.
Thank you, Madam Chair. Thanks for taking my question. Just on this piece about, the bill that passed last year versus this one, there was some testimony that, it was similar, but it was your testimony that it's not similar, that this one would apply to, laws or regulations that are already on the books.
Yeah, thank you for the question. So there were a couple of versions last year, and as this body will remember, the Senate couldn't agree with some of the House language, some of which is back around this time. And originally, they had a start date for any new presidential orders, laws, regulations. In the version that ended up coming over to the Senate at that point, and this current version, it doesn't have any reference like that. There's an implementation date, but we're talking about any federal law, regulation, order that has existed in the past or could be forthcoming. That, I don't think that this body has, I haven't heard testimony here today that addresses all the potential concerns that could arise from that.
Okay, are there any further questions from Ms. Rice-Hawkins? Okay.
Thank you very much.
Thank you very much. Okay, are there any other members of the public that would like to speak to House Bill 1178? Okay, Okay, seeing none, we'll close the public hearing. We did, Mr. Head was here. Richard Head? No. Oh, from the judicial branch, no one from the Department of Justice. You. Yeah, you can ask them. Oh, goodness. Oh, all these people want to speak. Yes, I know Justice. Yeah, she already told me. For Senator Susie. Okay, Bill, I'm just gonna open the public hearing and I'm gonna step away for a few minutes. I'll be right back. Okay. Are you,
I'll probably be asking you about. No, totally. Pull it up there. It's gonna be one page cheat sheet now. So I got 2 lots.
about an hour behind? We caught up and then we got. Okay, come on. We gotta keep going. We gotta wait for Senator Con. Okay. You all set? Gonna go ahead and open the public hearing on House Bill 1625 and recognize the prime sponsor, Representative Kelsey. Okay, I'll be right back.
Good afternoon, Madam Chair and members of the committee. For the record, my name is Nikki Kelsey. I represent Bedford Hillsborough District 7. I come to you today with the Sidewalk Free Speech Act. Freedom of speech is protected not only by the U.S. Constitution, but by New Hampshire's Bill of Rights. Our state constitution is even more adamant that our federal First Amendment, Part 1, Article 22, says that free speech should be inviolably preserved. Yet, free speech faces growing threats at both the federal and the state levels from those who would suppress their opponent's speech because they fear losing an open contest of ideas. These threats should be reminders of why freedom of speech is protected in our Constitution. Supreme Court Justice William O. Douglas once said that freedom of speech may indeed best serve its high purpose when it induces a condition of unrest or even stirs people to anger. Speech is often provocative and challenging. That is why freedom of speech is protected against censorship or punishment. Abortion is one issue where there is unrest on both sides of the debate. But New Hampshire's buffer zone law represents an attempt to stifle the contentious debate surrounding abortion rather than allowing freedom of speech to serve its purpose. The buffer zone law allows abortion clinics to demarcate a 25-foot zone around clinics in which nobody may counsel against or protest against abortion. Supporters of the buffer zone law may claim that it functions to protect women who are seeking an abortion from being assaulted or harassed. But the truth is that assault, criminal threatening, and harassment are each already illegal in New Hampshire. The actual effect of the law is to privilege pro-abortion speech and marginalize speech critical of abortion. The bill that's introduced would repeal the buffer zone law, yet it should merit the votes not only of the pro-life or even those who simply champion free speech, but of all those who value responsible government. That's because in 2014, Massachusetts buffer zone law was declared unconstitutional by the U.S. Supreme Court. Our buffer zone law is identical in all relevant aspects to the unconstitutional Massachusetts law. If our buffer zone law is legally challenged, it will be repealed, and New Hampshire will have wasted taxpayer money defending a law that is not only unjust, but unconstitutional and futile. For all those reasons, the buffer zone law should be repealed. And I thank you for your time this afternoon. And I'll try to answer any questions.
Thank you. I'm going to start.
Okay.
Just because I got the gavel, so there are good things about having a gavel. So Coakley, I read it over the weekend because I knew we were doing this. And so it seems clear on that it's a free speech issue. It would go under strict scrutiny because it's a important right. And so under Coakley in the decision, they, as long as you weren't impeding traffic, so you were allowed, the 25-foot zone was way beyond what is necessary. So they can pass laws that are necessary for public safety.
Yes.
And so as long as you're on a sidewalk that's wide enough to let someone pass, should be what I see Coakley is saying. You can't interfere with anyone. There's rules in the books. You can't block doors. I guess if you started impeding people in like a pathway, I think you might have a problem. But as long as you leave enough room in a public walkway, that's what you're after, and that's what Coakley seems to be. And you just want this codified.
Yes, that's exactly what this is. And let me just remind everybody that harassment is already against the law.
Yep.
So that law already protects women going into these clinics.
Okay. Anyone else? Go ahead, Senator Khan.
You said an if then relative to a challenge of our current law. Our current law has been in place since 2014. Is that right?
Yes, but the zone has never been demarcated, so the law has actually never been used.
Never been challenged either.
No.
Okay, thank you.
Go ahead, Senator.
Thank you. Thank you, Mr. Chair. Thanks for taking my question. So certainly, you know, the issues that you're raising are important, these constitutional balances that we really need to consider. But isn't it true that there are that there are other sort of buffer zones that we do allow because they're balancing certain interests? Like, for example, polling places in every state have buffer zones where people can't campaign, right? And that's in order to protect and allow people to safely express their right to vote. So there are certain buffer zones that are permissible, isn't that correct?
Yeah, there are.
So, did I have anything else? Wait. Since 2014, has New Hampshire had any problems at any abortion clinic with any protesters violating the buffer zone or being arrested for other reasons?
I can't answer that. I can say they have not demarcated the zone, though.
Okay.
So they have not used the buffer zone. And again, it is against the law for harassment.
Okay, thank you. You're all set.
Thank you so much. Thank you for your
testimony.
time.
No problem. Is Senator Susie here? Oh, she was gonna speak. Oh, okay, great. Thank you.
Thank you. I get the understudy, that's right. B team.
Good afternoon, Mr. Chairman, members of the committee. For the record, my name is Jess Espeland. I am the Minority Senate Public Policy Director. I am delivering Senator Soucy's testimony representing District 18. She couldn't be here this afternoon, but had some important points she wanted made. As you may know, Senator Soucy, as Senator Khan had mentioned, introduced the buffer zone law in 2014. That was Senate Bill 319. She did so at the request of Manchester residents who contacted her who had really alarming and, more importantly, threatening and what they felt were dangerous interactions with protesters when they were trying to access reproductive health care facilities, certainly behavior that went far beyond the idea of prayer or counsel. She had concerns also for the healthcare professionals going to and from work, certainly that anyone going to and from work should be able to do so safely regardless of where they are working. The current buffer zone law walks the fine line between public safety, private rights, and free speech. It's important to note this statute is directed at behavior, problematic behavior, not at free speech. 25 feet is about the distance of 1.5 city parking spaces. It's a narrowly tailored corridor that ensures entrance and the area immediately surrounding it is clear for vehicles and pedestrian traffic. Outside the buffer zone, current statute places absolutely no limits on what can be said or how it can be said. Protesters and folks' voices can still be heard and signs can still be easily read. Current statute does not favor one side of the abortion issue over the other. It simply establishes a safe corridor passage. And to Senator Whitley's point, there's plenty of precedent in New Hampshire for balancing competing state interests. New Hampshire law also creates a minimum 10-foot buffer zone around the entrance to polling places, and we prohibit any picketing or protesting within 150 feet of memorials and funeral services. It's worth noting the Supreme Court itself has enacted a 250-foot buffer zone on the plaza outside its own building. This issue is one of safety and balance. It's critical to maintain these statutory protections for folks trying to access health care, and I would encourage you on Senator Soucy's behalf to find this bill inexpedient to legislate.
Do you want to take a question?
Thank you.
Yeah, we can skip it. I'll have somebody
You
else.
can certainly follow up with Senator Soucy. I
I'll
would want
follow
to
up with
answer on
someone
her
else.
behalf,
Okay.
but there are plenty of folks you'll hear
Thank
from.
you.
Thank you.
I'm sorry. I gotta get used to this. Bob Dunn. I thought I saw you in the back. No? Okay. You're not usually shy in words. George Stanley. I can't hear him. Oh, I won't totally screw up. Zephyr Wood. Come on down.
Hello, so my name is Zephin. I'm a citizen, taxpayer, and active participant in my community. Regardless of one's stance on abortion, in fact, I'm generally against all government imposed restrictions on it. It has been a long-held American tradition to engage in freedom of speech and expression. This bill seeks to legalize the exercise of the First Amendment on sidewalks. More specifically, it allows for protesters to protest abortion clinics on public walkways, i.e. sidewalks. To me, there's no logical reason as to why someone should be barred from freedom of speech on the sidewalks that they fund with their tax dollars. This also sets a dangerous precedent. If protest is illegal in one aspect, even if it's something that you agreed with, what's to stop there from being restrictions on speech for things that you do believe in? As the famous saying goes, first they went for the communists, but I did not say anything because I was not a communist. And then it goes on and it says, then they came for me. And by that point, there was no one left to speak for me. To add a small constitutional note that demonstrates how absolutist the federal government is in relation to free speech, Brandenburg versus Ohio held that government cannot constitutionally punish abstract advocacy of force or law violation. In other words, basically most speech is constitutionally protected as long as it doesn't incite imminent lawless action. Additionally, there's a famous quote by John Stuart Mill, who was basically the founder of the idea of a free marketplace of ideas. He says, he knows only his own side of the case or argument, knows little of that. His reasons may be good, and no one may have been able to refute them. But if he is equally unable to refute the reasons on the opposite side, if he does not so much as know what they are, he has no ground for preferring either opinion. So essentially, to reach an informed decision on whatever the issue is, it could be gun rights, could be abortion, could be whatever issue, take your pick. We need to be allowed to talk to each other. We need to be allowed to use these public places as they were intended for, which was for the protection of this very, very vital right that we hold dear. And to be completely honest, this bill is kind of a softball and should definitely be signed into law without hesitation. So please OTP HB 1625 and legalize free speech on public walkways. Thank you very much. If you want to ask me a question, you can, but.
I'm going to ask you a question.
Yeah, sure.
And I'll go to next. I don't know. There's already been a Supreme Court decision on it, Coakley. I'm very confused why we're here when there's, other than we're trying to get something off the books. I don't understand, do you, why we're doing something that the Supreme Court has already set precedent on in exactly the same circumstance? Am I missing something?
So the Supreme Court generally talks about the issue of chilling speech. And so even if it is the federal law in the books right now that nothing is stopping you from protesting in front of an abortion clinic, I think that there's a lot of people out there that basically think, oh, well, New Hampshire law says that I can't, and so basically they're not going out there and engaging in their First Amendment protected right to freedom of speech.
I'm good. Thank you. Sendwith.
Thank you, Mr. Chair. Thanks for taking my question. You might have heard my question to the sponsor about, other buffer zones. So, so is your testimony that all buffer zones should be eliminated at funerals, voting places? From what I take from your testimony, you're saying that all buffer zones should be eliminated?
So on a personal level, yes, I basically am a free speech absolutist. I think it's a very, very important right. However, even under the Supreme Court, I believe that you're referencing like the time, place, and manner regulations that the Supreme Court has laid out in prior Supreme Court decisions. I think that if the Supreme Court reviewed this, it's just very clear that it's constitutionally protected. I mean, freedom of speech has strict scrutiny that they apply. So basically, there has to be a really, really, really good reason that you're restricting the speech. And given the fact that if anybody is inciting lawless things like, harassing somebody or any of these things that are already against the law, basically it would already be enforced that way. This law basically just restricts law-abiding citizens, people that are nonviolent, that want to peacefully demonstrate in front of buildings on publicly funded walkways, which I think is just morally abhorrent.
Thank you. Anyone else? Thanks very much.
Thank you.
Ian, come on down. Hewitt.
Good afternoon, Mr. Chair and members of the committee. Ian Hewitt on behalf of Cornerstone in support of House Bill 1625. We think that the unconstitutionality of the buffer zone statute is essentially at this point just an academic issue. Since this law was enacted in 2014, there have been numerous attempts to repeal it. Every single time, clinics and especially clinic escorts have come before the House Judiciary Committee and said that this law is necessary because of rampant crimes that are allegedly being committed against women seeking abortions, and a buffer zone is going to be demarcated any day now. That, of course, has not happened. No buffer zone has been demarcated, which means that we can't challenge the law in court because no one has standing to bring a suit, and that's the only reason this law is still around. The committee can see just by simple observation that this law is so without a prayer unconstitutional that it can't be enforced, will never be enforced, and the only purpose it's serving on the books is to chill constitutionally protected speech. I did want to make myself available to talk about why it's unconstitutional, including speaking to why it hasn't been enjoined, comparing it to electioneering laws or similar issues. One thing I'll note just off the bat is we've sometimes had bills in New Hampshire on both sides that in the past have been created without relevant legal expertise, and that's led to avoidable errors. And I think that's exactly what happened with this law. I'm thinking especially of Section 38B, which has an explicit carve out for patient escort services only. That is language that was not in the Massachusetts law, which was the template for this law. And that is language that no constitutional lawyer would have added. Legally, the only thing that language really does in the law is make it easier for a lawyer like me to argue that this statute is content discriminatory and so should be subject to strict scrutiny. The template Massachusetts law was unanimously invalidated by the United States Supreme Court, even though the court found that law was content neutral, and so in fact was subject only to intermediate scrutiny. So our law is as or more unconstitutional than the template Massachusetts law, which is why it has not been used for 8 years and why the committee should act to strike it down. And I'm happy to take any questions about the statute or related legal issues.
So thank you for reminding me about content-based restrictions always fail. You remember in law school? Did you go to law school?
I am a lawyer, yes.
Yes, so you do remember that. Remember? You remember we all sang the song? Oh, okay. We sang little jingles back in the Stone Age, and that reminded us that content-based restrictions always fail. Rick picked it up. And content neutral, thank you for reminding me. So again, Coakley, as long as, if you were on a narrow sidewalk, that would be their only argument, right? If there was only enough room for someone to walk and there was no room for someone to stand, then they might argue that there was no less burdensome alternative. Correct? But if there is room for the protester and room for a pathway, then you're all set.
Well, as we know from Coakley, this fails intermediate scrutiny. So the intermediate scrutiny the U.S. Supreme Court applied in Coakley was not strict scrutiny, which would apply to a content-based restriction. Sure. They didn't treat it as a content-based restriction. They just applied the intermediate test of, does it burden substantially more speech than is necessary to achieve the government's interests? In that case, you don't always fail. There are laws that could pass a test of that kind. Buffer zone laws don't pass that test because the proffered interest is preventing harassment, preventing obstruction of entrances. Those things can be prohibited directly, and the Supreme Court said, if you don't have laws on the books that effectively prohibit those things, pass new laws, is what it said to Massachusetts. And it even suggested some possible laws that Massachusetts could pass. So even if we didn't have sufficient laws, which I agree with Representative Kelsey, I think there are sufficient laws on the books for all these problems to the best of my knowledge. But if we didn't have them, the legal answer would be pass new ones, not enable buffer zones.
Thank you. We are all set. Thank you very much for your testimony. Gabe Holden. Welcome.
Thank you. So as someone who is very strongly pro-choice, this is sort of an admission against interest, but that's really not what this is about. I mean, so I can see why you would be comparing it to some similar rules with, decorum, essentially. But that's really not what this is about. Like, this isn't about, like, oh, how much room do you need? This is about targeting for political purposes. I mean, not every political position has a geographical area that's directly associated with it, but in the circumstances where you do have a specific area where, like, that is the place where these conversations can best take place, to target those in such a way as completely favoritist to one side or another. And I mean, it's a really dangerous precedent to set. So I mean, all of the important parts of this we already have rules for. Like, we have rules about not impeding someone, not, intimidating someone. I mean, we have all of these rules. We're not trying to strip any of those. So I mean, I trust the individual's judgment to make sure that they're not violating these basic social norms when they go to express their opinion. So all of the good things that this does, we already have rules for. And the bad thing that this does is, I mean, it opens a possibility that I don't like to see where it can be used in the future. And if you have any questions, I'll take those.
Nope, I think we're all set. Thank you very much. Karen Manowski? Good afternoon. How you doing today?
I am well. How are you?
Good, couldn't be better.
Thank you.
Thank you.
My name is Karen Minowski. I live in Goffstown, New Hampshire. I'm a retired occupational therapist with degrees in biology and occupational therapy. I'm also a mother, and I'm a post-abortive woman. I'm here to urge the committee to vote ought to pass on House Bill 1625 and repeal New Hampshire's so-called buffer zone law that allows private abortion clinics to ban assembly on nearby public land, including sidewalks. I can cite what I feel are 3 compelling reasons to do so. First, the law itself is unconstitutional and a clear infringement of our First Amendment rights. It's interesting to note that while these clinics have fought any effort to repeal the law, they've never once tried to enforce it. A quiet admission that it would never hold up in court if challenged. If there are other laws on the books to deal with truly unlawful or disruptive behavior. Second is my own personal experience. I have taken that long walk through the doors of an abortion clinic. It was a time of great fear and isolation. As I speak to you today, I'm thankful for the gift of my 2 grown sons, but I continue to grieve the loss of my first child. I would have welcomed an opportunity to pause and speak to someone who cared enough to be there. It might have made a life-impacting difference for me and my unborn child. Third, I've been one of those who have stood on the sidewalk outside abortion facilities in New Hampshire. I can speak from my own personal experience that we don't gather to be disruptive or interfere, but to be a caring and loving presence for women and their partners at a very difficult time. Whether they choose to engage with us is entirely up to them, and not every exchange is about abortion. Recently, I can remember one young man who wanted to talk about a difficult situation with his 2-year-old son. I was able to be with him in that space and offer him encouragement as a father. Others have simply wanted to ask questions or engage, and we're happy to do that when we're invited to do so. So I ask you to please vote to repeal this unconstitutional infringement of our ability to gather and be present for women and their partners and families at an incredibly stressful and trying time. Thank you.
Sorry. Thanks very much, Senator. Any questions? Thank you, Senator Woodley. Thank you. We're all set. Thank you. Beth, is it Scara? Scara? Welcome, Beth. Thanks for your patience waiting for us.
Yeah, I'm Beth Scare from Nashua, and I'm testifying today to ask you to pass HB 1625, the Sidewalk Free Speech Act, to repeal the unconstitutional buffer zone law, which allows private abortion businesses to designate up to 25 feet of the public sidewalk and street as no free speech zones. And I made a countdown of the top 10 myths. So like a David Letterman skit. But in the interest of time, I'm going to cut back on that. I did want to call out that the buffer zones around polling places are nothing like this, nothing like what's in the law, because polling places, you can sit and have a snack, you can talk to a friend, you can make a call. None of that's allowed in a posted buffer zone. It's a totally different situation. But starting with myth number 4, buffer zones protect abortion facility staff and clients from violent acts. Buffer zones, this is a really common misunderstanding. Buffer zones don't provide any security. Anyone can walk right through the buffer zone. There's no fences. And someone could even make an appointment, be inside the building, and commit a violent act, and the buffer zone would have made no difference. Myth number 3, abortion facilities need buffer zones to give their clients space. Well, the Lovering facility, the Lovering Health Center, it says in their volunteer sign-up form that they don't worry about people congregating outside their facility, and they don't have escorts. Ever since they moved from Portsmouth to a large piece of land in Greenland, clients in Greenland, their clients can drive in and out on the long driveway and leave the facility without interacting with anyone except the staff and other clients. And all these abortion businesses claim that what Lovering has is what they want for their clients, except they want to take public space to create that buffer. Lovering made the investment, they did the work to create a setup where they have a buffer built in. And myth number 2, clients are physically being blocked. I think I just may have heard that from another person's testimony. If that is happening, there's a federal law, Freedom of Access to Clinic Entrances Act, makes it a federal crime to physically obstruct the entrance to a clinic. And from Kayla Montgomery, speaking at the House hearing, claimed there was an incident where the driveway to Planned Parenthood in Manchester was blocked, but she couldn't produce a police report. And they have lots of secure video surveillance. They could have had lots of evidence if it had happened. And there's no reason why they shouldn't just prosecute these actions, these bad actions, if they're happening. And the number 1 myth is that they're buffer zones, and I'm sure you're going to receive lots of testimony to this effect, that the buffer zones are currently protecting people. But there are no buffer zones. There never will be buffer zones. And this serves no purpose except for to shut down free speech. So I'm asking you to please vote ought to pass on this bill and repeal this law, which helps no one, protects no one, and is a serious infringement on our God-given and constitutionally protected freedom of speech.
Thank you for your testimony. And seeing no questions, you are all set. Thank you very much. Dahlia, I'm going to give it a guess. Rodunas? No, give it a try. Thank you. Welcome, Dahlia.
Thank you. Good afternoon, and thank you for listening to my testimony. My name is Dahlia Badunas, and I am the Executive Director at the Equality Health Center here in Concord. And I'm asking you to please oppose House Bill 1625 and to keep buffer zone laws here in New Hampshire. New Hampshire's patient safety buffer zone law, which was passed by bipartisan support in 2014, protects patients and provider safety and privacy at reproductive health centers. It was intentionally designed to strike a balance between patient safety and an individual's First Amendment rights. For the first several years after this was passed, Equality Health Center worked diligently with the city code enforcement, with the Concord Police Department, with the mayor's office, to come up with various ways to protect patients from protesters while protecting the protesters' right to free speech. It was a very uneasy compromise, and it semi-worked, not really, kind of, sort of, but we went with it. because at that point in time, we didn't have so many protesters and they weren't incredibly aggressive. As a matter of fact, during that period of time, I personally met with the leader of Concord's 40 Days for Life protest group in attempts to try to work out compromises so that we could work on the patient's behalf. And we came up with agreements of terms on things like what kind of signs they would use. They agreed not to use the really horrific, bloody, disgusting signs, the voice volume, and different things like that, and how to approach patients. However, just before the COVID pandemic, EHC became the target of an incredibly nasty group of protesters who refused to work with us on behalf of patients. These protesters began blocking our entryway. They violated noise ordinances several times. They used disgusting, bloody signs that are blown up that can be seen by the patrons of the children's bookstore right across the street from us. And since COVID, it's gotten worse and worse. As I attempted to ratchet up protections for our patients, the city requested that we try yet other means. We did things like getting permits ourselves to be the protesters in front of our own building. We got permits to be a vendor to sell items in front of our building. We got over 4 or 5 different kinds of permits just to stop the protesters from being directly in front of our building. We have also, during this time, we have called the Concord Police Department well over a dozen times to help settle different disputes. There has been an arrest. A protester was arrested. One of our escorts brought forward the complaint because our patients, who are the victims of these protesters, are too afraid to bring forward complaints. They do not want to see these protesters again. Now, 2 years later, I have been advised by people within the city that a Quality Health Center has to get its own attorney to enforce the buffer zone. Period. Even though it is a law here in New Hampshire. So you may ask why we waited so long. And we truly believe in the First Amendment, and we have tried to work out our differences with these protesters. However, as they've gotten worse and worse and more belligerent, aggressive, and hostile, it has become absolutely impossible. We now have people crossing state lines to protest at a Quality Health Center, with the biggest group coming from Portland, Maine. And what happened on April 8th in front of a Quality Health Center just 10 days ago can never, ever happen again. We had 22 protesters in front of that small area in front of a Quality Health Center. 2 different groups, the 40 Days for Life, who had a permit, and then the group from Portland and also from parts of New Hampshire right there. 22 people. And on that day, we were seeing abortion patients. We were seeing birth control patients that just wanted birth control. We were seeing people to be tested for HIV and for STDs. We were doing pap smears on that day. We were not just doing abortions. However, every single person that came by was accused to be a murderer. On that day, in front of those 22 protesters, a patient came in for services who was suffering from very severe hyperemesis. She had been in the hospital already on numerous occasions for her dehydration. After she signed in at EHC, she decided to go across the street with her partner to get something to drink at the cafe at the bookstore. When she was there, she threw up all over herself and passed out. Her partner ran across the street, grabbed some of the escorts that are in front of a Quality Health Center, and the escorts notified myself and several of the other staff, and we ran over to assist her. After we cleaned her up in the bathroom, and thank you so much, Orrin Reno, I so appreciate it because we made a mess of their bathroom. After we cleaned her up, we brought her some scrubs from a Quality Health Center and tried to get her steady enough to cross the street. We walked across the street, her partner on one side, myself on the other side, holding her up because she was so unsteady. As we approached the sidewalk, she started retching again. At that time, the protesters came up and tried to block her from coming into her doctor's office. She was going to a medical appointment in her doctor's office, and they blocked her from entering our facility. The protesters, at that point in time, they were encroaching on the patient's right to seek medical care, period. And if it weren't for my being a fairly large-sized woman, feeling okay to push them aside, we would not have been able to go in. Now, you ask as to why aren't the protections that are already out there doing something about this? And again, it's because what has to happen, we call the Concord Police Department on a regular basis. If the person this is happening to refuses to file a report, they will not move forward. Patients seeking medical care do not want to face their protesters again and tell the world what medical procedures they were receiving and why they were there in the first place, even if it's for birth control. They don't want to do it. So this was so egregious that happened 10 days ago. We did not call the Concord Police Department because the patient did not want to file a charge. However, it was so horrific, I contacted the FBI and have filed a formal complaint with the FBI. Unfortunately, because the patient is not willing to move forward, this will probably not go anywhere, which is really unfortunate. But the FBI thought it was serious enough that they actually sent someone in to speak with me about it. As the patient safety zone allows health centers to establish safety zones up to 25 feet based on the city and the police to determine what's in the best interests of the community. When I've been working with Concord, they have been talking about doing approximately a 10-foot safety zone because we are right on Main Street, understanding that 25 feet may not make the most sense, but because our facility entrance is right there on the sidewalk, that we would need a minimum of 10 feet on each side. We do feel that that would be adequate, that patients could get their routine medical care without feeling persecuted, because these are patients that are being protested, that are getting birth control, cancer screenings, STI testing, behavioral health treatment. 2 weeks ago, we had protesters screaming at one of our behavioral health clients, telling them that they were a murderer and they were coming in for mental health services. As states move to ban abortions, protesters have honed in on the states where legal abortion care is still legal, and it's escalating the violence. Attacks on reproductive health centers continue to escalate, including, I don't know if you're aware of this, but a Planned Parenthood in Tennessee was recently burnt to the ground just a couple of months ago. EHC has also seen an increase to damage to our property since we have had more protesters. We've had trash being strewn all over our grass and our parking lot. We find hundreds of nails in our parking lot on a regular basis now after the protesters leave. Whether or not they're the ones that are putting them there or not, I don't know. But that can be nails in our tires and all that. We actually had our building egged after the last executive council meeting, rejecting our family planning application on the sole basis that we perform abortions. And we had several dozen eggs all over our building. Because of the severity and how horrible these protesters have become and how violent we feel they have become, this month, Equality Health Center installed an electronic surveillance system, and we updated our alarm system. And at this point in time, because several health centers have actually been shot at, we are now looking at grants to replace our windows with bulletproof glass, because my staff is now afraid to sit by the window and answer the phone. So I ask you, on behalf of our patients who are attempting to seek legal medical care at Equality Health Center, please allow them to access those services without being harassed. That is all we want. We want them to be able to physically access their the services without being harassed and without having people try to touch them and get in their way of coming into the building. And with that, I ask you to please oppose House Bill 1625.
Thank you very much for your testimony. Are there any questions from the committee? Senator Gannon and then Senator Whitley.
Yeah. Well, I appreciate, and I want everyone who commits any unlawful act against anyone at your clinic prosecuted to the full extent of the law, and they have no right to harass or all of that. At the same time, just like you appreciate Roe v. Wade as the law of the land, it's precedent, right? The same thing has already been done in Coakley on buffer zones. They've spoken to the subject matter. They've dealt with buffer zones. They've said no less burdensome alternative can be done. So if they've spoken and said this, how can I ignore the United States Supreme Court and Coakley on buffer zones if our state law is unconstitutional? I know what you want, but it's already been dealt with by the United States Supreme Court.
And I am not an attorney, so I do not want to answer that legally. However, I do know that our buffer zone law is not exactly like Coakley, and therefore I think there are enough differences in there. Understanding what the problems were with Coakley, I think the differences in the New Hampshire buffer zone law have addressed those issues and therefore would not be unconstitutional.
Thank you.
Senator Whitley.
Thank you, Madam Chair. Thank you for coming here to share what actually happens. It's particularly important for me to hear that. This is your facility is located in my district, right downtown, and so it's important for us to be, really aware of, about what's going on. And you said that you had seen an increase in protesters and sort of the nature of the protesters, and I'm wondering, in terms of timing, right? We are approaching potentially this summer, the U.S. Supreme Court could overturn Roe v. Wade. So I'm wondering if you have any concerns about repealing the patient safety zone when we are approaching such a tenuous time in
yes, very much so, which is why Equality Health Center, if this is not repealed, will be getting our own attorney to then force Concord to allow us to do the buffer zone, just as Concord told us that we had to. We want the buffer zone. We will be enforcing it if it stays in law. We have to have it. Our patients are scared to death of these horrible protesters that are so aggressive, screaming at them nonstop for services they're not necessarily there for. And to be honest with you, I mean, when we do a lot of miscarriage management, which also falls under abortion type services, and when you have somebody who is suffering from a miscarriage, from a wanted pregnancy, to be called a murderer and Satan's spawn, as they're ending a pregnancy that they so desperately wanted, the effects, the emotional and psychological effects. I have seen women walk past our door and then just crumple down in a fetal position, sobbing. And we're unable to move them for like 10 minutes because they're just sobbing so hard at what the antis have said to them, what the protesters have said to them.
Senator Khan.
Thank you, Madam Chair. Sorry to hear your testimony, but it's important for us. And your staff is what's occurring to me. And clearly the aim of the protesters sounds like to harass your clients, but you have a staff, I assume, that are victims of this kind of harassment as well. And so how do you, what do you think is the appropriate response in that instance?
That's a very, very difficult question, and I appreciate it because it's something that I wrestle with all the time. Even though we did not have the financial ability, we took out a loan to put out security cameras because we felt it was that important for the staff safety. We're looking at grants to get bulletproof glass. Staff are not allowed to come in and out of our building in scrubs because we are afraid that they will be followed home and harassed. I have been followed on numerous occasions by protesters. So I don't know what our answer is other than my staff is so dedicated and care about our patients, regardless of the services they're obtaining, that they're willing for the lousy wages we give, unfortunately, because we can't compete with hospitals. They're willing to defy those protesters and come in and support our patients and give them the service that they so deserve. I don't know of a lot of other doctors' offices, and we're truly a doctor's office. We only have 2 providers, mental health and 1 physical health. I mean, we're a doctor's office. I don't know of any other staff in doctor's offices that would put up with what my staff do, and they are remarkable people. I wish I knew how else I could help them more than what I am already doing.
Thank you.
Are there any further questions? Seeing none, thank you very much for your testimony.
Thank you very much. I appreciate your time.
The chair will call Liz Canada. Thank you.
Good afternoon, members of the Senate Judiciary Committee. My name is Liz Canada, and I'm the Advocacy Manager for Planned Parenthood New Hampshire Action Fund and Planned Parenthood of Northern New England, and we oppose House Bill 1625. So first is quick background. You've heard a little bit of this already. This body passed Senate Bill 319, and it was signed into law in 2014. The legislation was to address public safety concerns by allowing a non-mandatory patient safety zone of up to 25 feet surrounding entrances to reproductive health facilities. This flexibility allows for communities to tailor a zone in accordance to their local factors and their public safety needs. I want to explain why patients and providers need the flexibility to use a patient safety zone. Reproductive health centers in New Hampshire have always experienced protest activity, and I know you just heard from, Equality Health Center on some of those more recent ones. And as she said, and I can also say for Planned Parenthood, in the past few years, the volume and frequency of protests have increased, particularly since the pandemic began. So the types of harassing tactics our local health centers have dealt with include obstructing the driveway entrance. So protesters gather in front of the driveway and often block it with a physical object at the entrance, which creates barriers for patients getting in and out of the driveway, and forcing the patient to unnecessarily wait as the driveway gets cleared. Protesters invade the privacy of those who do not want to engage in dialogue with them while entering or exiting the building. There is protesters who block on-street parking. There are verbal assaults, which you just heard from Equality on that issue as well. There's also photographing patients and staff and then posting those photos online. This is all a violation of patient privacy, but it is also a major public safety issue. In fact, the unnecessarily congested driveway has caused patients to become confused and distracted and has led to minor car accidents. To try to help mitigate this public safety concern, PP&E installed a new fence at the Manchester Health Center to help patients navigate that issue. So while the fence is better for public safety, it does then change the issue of privacy of patients walking in and out of the parking lot and now being able to be very visible to the protesters right there. So PP&E is forced to trade patient privacy for public safety when in fact, everyone deserves to have both. Currently, Planned Parenthood uses on-site security on certain days, and that totals $25,000 per year, and calls to the police are more frequent. So establishing a patient safety zone is just one tool in the toolkit for health centers and for local authorities to use when working together to protect public safety and privacy to patients and providers while also balancing First Amendment rights. It is not necessarily the first or only tool in the toolkit, but local health centers and local communities must have the flexibility to use a patient safety zone if needed. So, in conclusion, no one should face violence, harassment, or threats when accessing safe legal health care. Everyone, from the governor to legislators to patients, deserve privacy and safety when they are on their way to accessing their care. Planned Parenthood recognizes and supports a right to peaceful free speech, and having this law does not remove free speech. It just gives local health centers a small area of separation for privacy. We urge you to ITL House Bill 1625 and keep this carefully balanced law.
Sorry.
That's okay.
Thank you very much for your testimony. Are there any questions from the committee? Senator Khan.
Thank you, Madam Chair. We've had a lot of emphasis on the Coakley decision in Massachusetts. You've gone on to describe some other places where the buffer zones have been upheld. I guess my question is, there's ambiguity as to where the courts lie on this question.
Thank you. Thank you for that, Senator Khan. So, and I want to clarify something that I heard earlier from Senator Gannon as well. So, the New Hampshire law is not identical to the Massachusetts law that was struck down. They are not identical laws. So, the Massachusetts law required that every reproductive health center have a buffer zone. It was in place at every health center. And it was required that it was 35 feet from the entrances. New Hampshire's law does not have either of those factors in it. New Hampshire's law is flexible. It is the New Hampshire way to be flexible. New Hampshire's law says that a reproductive health center can have a buffer zone, but it is not required to have one. And it is allowed to have a buffer zone up to 25 feet. It is not a fixed amount like Massachusetts was. So those are two important distinctions between the Massachusetts law, which was decided unconstitutional, and New Hampshire's. Beyond that, we have other buffer zones that are in place across the country. You're right, there are about, I believe it's like 14 states plus the District of Columbia that has these allowances when it comes to reproductive health care facilities.
Senator Whitley.
Thank you, Madam Chair. Thanks for taking my question. I mean, so you actually, in your testimony, you had cited a buffer zone law in Pennsylvania, and that in fact the Supreme Court had left it in place. Is that analogous to our law?
Yes, I don't know the intricacies of that law off the top of my head, so I can look into that. But that was a recent decision to uphold that law. Yes.
Thank you.
Are there any further questions?
You
Senator
could just tell me,
Gammon?
you're probably more reviewed than I am on this. Thanks for taking my question. So your public safety zone is going to be a content-based restriction because you're doing it at a reproductive center. So if it's a content-based, as we had talked about earlier, it goes to a level of strict scrutiny, which makes it, you'd have to have no less, so they might have to look at the instance of where you are and on a street, but you would have to have no less burdensome alternative. So if there was a pathway and it was 6 feet wide, so traffic could flow in each side, 3 feet by 3, at the 7-foot level or something about there, you would have to let them protest. And if you don't, then you would be an undue burdensome. You wouldn't meet the most narrowly tailored means of a pathway. So would you agree if you had 3 feet and 3 feet or something like that, your 25-foot buffer would be way beyond what would be allowed by any law saying that you have to do it as narrowly tailored, as small as you can. 25 feet would be way over in most, depending on the location. If it's a 6-foot wide walkway, then you might have a point. But other than that, if there was room for the protesters, wouldn't you say you'd have to let them there?
So again, it's up to 25 feet. It's not a fixed 25 feet.
Okay.
And something that I heard earlier around whether it was specific to a type of content that's, you're speaking about how it's outside a reproductive health center. The Supreme Court decision, I read it this weekend as well, I heard you said it, you read it too. They said that just because it's outside doesn't mean that it's specific to that content, that one side of the issue. The New Hampshire law, it talks about providing patient escort services as being carved out. But in the definition of patient escort services, it specifically says that it does not include counseling or protesting of any sort. So they are not allowed to have that sort of conversation that would be one-sided. So I think that addresses some of your concerns that you said earlier.
Great, thank you.
Sure.
Okay, are there any further questions? Okay, seeing none, thank you very much for your testimony.
Thank you all.
The chair will call Jason Hennessy. Good afternoon, Mr. Hennessy.
Thank you, Madam Chair. Honorable members of the Senate Judiciary, thanks for hearing me. My name is Jason Hennessy. I'm a resident of Amherst, New Hampshire. I'm also the president of New Hampshire Right to Life, which is New Hampshire's largest group focused on pro-life matters. And I'm here to speak on behalf of our thousands of members in favor of HB 1625. So this bill has little to do with abortion and much more to do with how our government treats people peacefully exercising their constitutional rights on public property. As a state and as a country, we decided that free speech and the right to gather peacefully are core values that we have. We enshrine these in the New Hampshire Constitution, for instance, free speech in Article 30, and the right to peacefully assemble in Article 32, as well as the federal Constitution, the First Amendment. I believe that the only reason that this hasn't been struck down so far is because no abortion provider actually thinks it's worth using. It's been 7 years, and we have no instances of it being used. So how does it make sense to single out citizens who are pro-life in New Hampshire to quell the protected speech and assembly rights? We're talking about public property. If it's private property, that's an entirely different story. And people are welcome to go buy property where they feel like they can conduct their business. But this is public property. So why should private abortion providers be allowed to tell members of the public what they can and can't say on public property? What's next? Banning protesters from the sidewalks in front of City Hall or at the State House? Abortion providers have already told us that they don't need or want this law. While their words today say one thing, their actions tell a completely different story. If there were any sort of issues, you'd expect the abortion providers to have come up here and testified today and talked about all of the convictions that they had. But I didn't hear one reference to a conviction. So it's been over 7 years, and to conclude, I just want to ask, does New Hampshire want to be, for instance, like Russia, like suppressing dissent and war? Do we want to be like China, suppressing discussion about the atrocities committed against the Uyghurs? Or do we want to allow opposing viewpoints to be peacefully spoken in the public square? I hope that you will keep New Hampshire on the right side of history and vote ought to pass on HB 1625. Thank you.
Thank you very much for your testimony, Mr. Hennessy. Are there any questions from the committee? Okay, seeing none, thank you very much.
Thank you.
The chair will call Grace Kindecki.
Thank you so much, Madam Chair, and thank you to members of the committee for taking my testimony today. My name is Grace Kindecki. I am the program coordinator with the American Friends Service Committee. I'm also a woman. I'm also a longtime New Hampshire resident, and I'm here in opposition to this bill, and I urge the committee to ITL it. Not too long ago, I was a young woman seeking not only reproductive access care, I was seeking general health care. I needed a physical, I needed blood work, I needed a doctor. I was also an undocumented woman, and so the only place that I could go to that would accept me was the Planned Parenthood in Manchester, which is my hometown and the city that I live in now. So at the time, I remember I was, my boyfriend at the time, who's now my husband, would drive me regularly. We'd pick up any medication that I would need. He would stay with me for doctor's visits, all sorts of things. He's a wonderful partner. And one afternoon, for the most part, we had very little issue. I rarely saw protesters. I would go in. I always noticed that there was a tall fence around the Planned Parenthood in Manchester and a very narrow entrance to get into it. So, but for the most part, my experiences were great. Until one afternoon, I was going in with me and my husband, my boyfriend at the time, and we were leaving and trying to, and I don't know if you know that area very well, but it's very narrow. There's a kind of a one-way street there. You can park on both sides. And so you really have to take care as you're coming out of the parking lot for the Planned Parenthood to get onto the street. And there was a humongous group of people outside of that clinic, and they were yelling, they were holding horrific signs. And you all don't know me very well, but for those, for those who do, I know this is a public hearing. I love babies, I love children. I'm an aunt 11 times over. I have a big family, and so I've always been excited to be able to have my own kids. And so I knew when the time was right, I would do so. And so at the time wasn't right. And so what I was confronted with that afternoon was horrific harassment. I had people waving pamphlets in my face. I had people yelling at us. We had people blocking our car from being able to take that turn safely onto that street. And so I've been sitting here and listening to testimony after testimony, and I'm not a lawyer. I'm just a citizen of this country, and I'm your constituent, so I'm here to lend my support to my allies. As I've been listening to all of the testimony, I've been thinking about what is the law meant to do? It's both meant to protect as well as protect the people's rights, and it's meant to balance. And so I take into consideration that, the work that you have in front of you is complex, balancing the public safety with people's right to protest. But the reality is what the law intends to do is what actually happens versus what people are saying does or does not happen. People do experience harassment. I know you heard compelling testimony. And right now, what I want to make a note of, the point that I'd like to make is that, now I'm married, I live a comfortable middle-class life. I don't have to go to Planned Parenthood. I can go to Dartmouth-Hitchcock. And I can go to Dartmouth-Hitchcock without a single protester seeking the same exact care that I did at 22 that I'm now seeking at 35. And what I'm seeing is that these laws are meant to protect people, because what happens is that when you are going to a reproductive access clinic, when you are a low-income person, when you are undocumented, and your options are limited. So those are, for the most part, the places you can go, the places you can afford to go. And when you are confronted by people who are exercising their right to protest. Yes, they're exercising their First Amendment right, and they're steamrolling over my right to be able to access care safely, to be able to go into a place where I know that I need to get the care that I need without having to fight off a mob of people in order to get in and out. I experienced that here, and for the brief time that I lived in Boston, I experienced it there too. And so it's really disappointing and saddening and disheartening and heartbreaking to hear that these issues and these problems continue, and in fact that they've gotten worse. And so the reality is that we need laws that protect a very specific area, very specific place that people, yes, have a lot of feelings about. But the reality is that people are protesting Dartmouth-Hitchcock. They're protesting the Planned Parenthood. They're protesting the Equality Clinic. They're protesting in those places. And the people that they're harming are people who look like me. They're members of our LGBTQIA community. They're part of our low-income community. They're part of our undocumented community. And so it is, I hope, your duty and to take that into consideration and to think about not only who are we protecting, not just the theory of protecting our First Amendment rights, but protecting the safety of our citizens and our residents to access the care that they need, no matter how they can access it. And so I urge you, committee members, to please ITL this bill, and I'm happy to take questions.
Thank you very much for your testimony this afternoon. Are there any questions from the committee? Seeing none, thank you very much.
Thank you.
Okay, are there any other members of the public that would like to speak to House Bill 1625? Sir, would you come forward and identify yourself for the record?
I was on the list.
Your name is?
Norman Tebow?
Yeah.
Okay, yep, I see you. That's okay, we'll fix it. Good afternoon, Mr. Tebow.
My name is Norman Tebow. I live in Bedford, New Hampshire, and I'm the leader of 40 Days for Life in Manchester. This is our campaign to end abortion, as you've heard. I urge you to pass HB 1625 to remove this buffer zone from abortion facilities. Our campaign in Manchester takes place twice a year on the public sidewalk outside Planned Parenthood. It's peaceful, respectful, prayerful activity that in no way impedes or prevents anyone from entering or leaving that facility. In fact, we ask anyone participating to agree to specifically stay on the public sidewalk, to not obstruct or impede anyone, and to always behave in a lawful and respectful manner. We are there to pray for and to offer help to anyone involved with a pregnancy or a potential abortion. But I'm here today not to debate the abortion issue, but to support the First Amendment right to be present on that public right-of-way. The buffer zone law infringes on that right and is particularly egregious in that it only applies to one and only one specific type of place, the so-called reproductive health care facility, meaning abortion clinics. That's what's wrong with the current law. The government has singled out a particular activity as deserving special protection from speech. Under the guise of protecting the clients of the facility from harassment, it is really free speech suppression. I can also speak to some of the stories we've heard earlier today about clients being allegedly harassed. I'd like to ask where my buffer zone protection is as someone on the sidewalk praying peacefully when someone drives by on their car and makes an obscene gesture to me, or approaches me and starts to chew me out and ask me why I haven't adopted children. I had an experience last year where someone stopped their car, got out of it, made a sign with an obscene message about me, and followed me walking on the sidewalk for a half an hour. So I ask, where's my buffer zone protection? And the answer is, I don't want that buffer zone protection because that person who followed me for a half hour had just as much right to do what he did as I did what I was doing. That's what the First Amendment is about. It shouldn't be picking sides. Courts have said that these laws are unconstitutional, so why must ours remain on the books? If there ever is a cause that deserves bipartisan support, surely freedom of speech is it. For those in favor of keeping the buffer zone, please consider what your position would be if the shoe were on the other foot. If the law applied to an activity or a facility that you opposed. In that case, I suspect you'd be arguing that the buffer zone should be abolished, not kept. This pendulum can swing both ways. The speech suppressors can quickly become the suppressed, just depending on who's in power at the time. A situation I don't think any of us want. Senators, when speaking on any matter, how would you feel if your fellow senator sitting right next to you were able to invoke a law that required you to move to a location from which you couldn't be heard? I suspect you would find this unconscionable, and rightfully so. Yet this is essentially what the buffer zone law says to those of us peacefully praying on the public sidewalk. So I'm asking you to put aside partisan politics and special interest influences and support the freedom to peacefully, respectfully engage in prayer or any other lawful activity, regardless of your particular positions on any particular issue. For those of you that like to recite the mantra, I stand with Planned Parenthood. Does that mean no matter what? Does that mean in any circumstance? Does that mean in any particular situation? I ask you instead to embrace the mantra, I stand with the First Amendment, and I support the right of even those you disagree with to peacefully express themselves. So thanks for your consideration and for your service to our state.
Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none, thank you very much.
Thank you.
Again, are there any other members of the public who would like to speak to House Bill 1625? Ma'am, come forward and identify yourself for the record, please.
Hello. First time. I'm Cindy Hennessy. Yeah, if abortion centers had their way, there would be no opposition to them.
Excuse me, before you get started, could you just identify yourself for the record again?
Cindy Hennessy.
Okay, thank you.
Yeah, if abortion centers had their way, there would be no opposition. Of course, they want to silence their critics. They don't think they're doing any wrong by performing surgeries or giving pills to eliminate children. At Planned Parenthood, with upwards of 300,000 abortions a year, and maybe they get, I don't know, $1,000 each abortion, they want their business to grow, so any protesters must be silenced. There are a lot of successful sidewalk counseling stories. The people who are outside the abortion centers might be the last stop before women lose their children. And so if Planned Parenthood claims to be pro-women and pink friendly, as their marketing suggests, why would they want to remove people outside who want to offer help to women and their children? I mean, I don't approve of any disgusting signs, but what's worse, a disgusting image or a disgusting act of the image that's going on? If these centers just stopped doing abortions, I think the protests would stop. Like, they claim to know what is egregious and what is horrific, but I don't think they really do. For the civil rights protests in the 1960s, people went into the diners and sat in the booths. If there was a buffer zone, then they wouldn't be allowed to go into the diner and protest peacefully. Yeah, so, I mean, you can hear a lot of testimonies supporting abortion centers, but you won't hear the people that have been harmed by abortion centers because they were silenced, they were killed in the womb, so they aren't here today to provide their testimony. They didn't have a fair fight. So peaceful presence or offering help on the sidewalk or prayer, it's not a bad thing. There can be good that comes out of it. If something bad is happening inside the building, then shouldn't we say something? Shouldn't we expose what is evil? Okay, thanks.
Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none, thank you. Okay, last call. Is there anyone else who would like to speak to House Bill 1625? Okay, seeing none, we'll close the public hearing. The committee will be in recess until 5:30. Am I right? It's 4:45. Okay. I want to make sure that everybody has an opportunity to read the amendments to the fiscal bills. They were last minute needs. We got it second. So I want everyone to
I'm sorry? It's the amendment to 1103. Amendment to 1103.
Okay,
I
I
move
don't
we
have my
go into
thing.
executive
The
session.
committee will come out of recess. Can I?
You just moved
I
to
just
Oh,
moved.
oh, he's fast. Senator Khan to go into executive session, seconded by Senator Whitley. We have
pick it up.
a few bills that we must exec today.
Yes.
Because they're fiscal note bills and they've got to be out of the committee. My plan is, and it's taken some coordination with Senator French.
Yeah.
As you know, he has commerce in the morning on Tuesday. He says they probably need about an hour from 9 to 10 for him to conclude his work for commerce. So that is going to free up the rest of the day for us.
On what day, sir?
On Tuesday.
Oh.
So hopefully, instead of saying late,
What do you mean, no?
on Tuesday, we can start early. You don't want to, Senator?
Start early at,
Yeah, we'll start early at 10:30 with the public hearings.
okay.
I get confusing.
The education meets at 9.
Oh,
And-
okay.
and
Oh,
There's a pretty substantial number of bills that need to be
oh,
exec.
okay. Yeah,
Yeah, that's
I mean,
tough to,
if you said 11:30,
well, you can miss. a couple
possibly
here.
11, I think that's all we're gonna do. We're gonna need at least 2 hours,
okay.
at least.
All right, because I hadn't thought about that. So, okay, well, we'll have to go to Plan B and we might be here later because we have 6 bills we have to hear next week. And we've got to exec them out as well as what we still have.
So
So
that's the last day.
that's the last day. And I think we probably have at least 13 bills.
I think it's, remember we had this problem at the beginning of the year and the box for some reason. I don't even know if I see people that put stuff here or not, so. I think we just gotta get rid of here.
Okay, so the thing is,
So 15 current committee that happened.
okay, so we're going to do, probably about 5 or 6.
We have to do at least 6 because we have 6 items.
Yeah, we've got to get rid of all of those. And I think there's maybe one that we heard from today. And then the rest of them, we hear and exec next week. So please, everybody just get ready. We can't put it off for another week. We've got to hear these and we've got to get these out. And I've already told Senator Bradley, don't ever do this again. Don't ever do this again. This compressed schedule just is not working for us. I think we are one, if not the busiest committee. And this just really doesn't work too well for us, so. Okay, so I'm going to go numerically with the bills that we have. I think the first one is House Bill 1296. And we do have an amendment from Senator French. It is amendment number 1415S. And Senator French, would you walk us through your amendment?
Sure, I will. Let me get to it. My notes.
I'm sorry, 1296?
Yes, the first one is 1296.
Thank you.
So on page 1, lines 3 through 7, uses Chairman Gordon's refined waiver language. That was a change. And it adds at the end of line 17 through line 19, all forfeiture-related petitions shall be filed at and heard by the Superior Court that has jurisdiction over the criminal case. This addresses the court's concern about venue. All cases under this statute will be felony offenses, and once bound over, will be in Superior Court. At line 30, the Superior Court is specified. At page 2, line 15, the Superior Court once again is specified.
Well, I'm sorry, Senator, what was that?
Page 2, line 15, the Superior Court is specified. At page 2, lines 27 and 28, replace the language of page 5, lines 2 and 3, as amended by the House to address an issue raised by the court. At lines 31 on page 2 through line 4 on page 3, we replace 5 from page 5, lines 6 through 8 of the House version to better address the process in the court. At page 3, lines 8 through 9, the specific rules the court will use are inserted. At page 3, line 33, the Superior Court is specified. And lastly, on page 5, line 5, the Superior Court is once again specified. While the amendment is 5 pages long, most of the language remains the same. Changes were made to address concerns raised by the court. The result is a bill with a well-defined process which protects the due process rights of all people. Are you listening to me?
Page 5.
Page 5. Line 5. The Superior Court is specified. Got it? Thank you.
Okay, is there a motion on Amendment 1415S?
Move on to pass.
Okay, Senator French moves on to pass. Is there a second?
I'll second.
Seconded by Senator Whitley. Okay. Is there any further discussion?
So in
summary,
yes,
it's a much better bill.
because
the courts, it addresses the concerns the courts had with it.
meaning that there isn't the confusion between a circuit court and a superior court.
Correct.
And is this shifting everything to the superior court?
I believe it is, yes. Where it should be.
In the event that it's a criminal case.
Right.
And that was our discussion.
Yep.
Primarily.
Okay, Senator Whitley? Oh, I thought you had a question. No. Okay. Okay, so we have an ought to pass motion on Amendment 1415S.
Let me ask one other question
Sure.
on this. The other thing that this assures is that because it goes to the Superior Court, it assures a public defender defense as opposed to an ex parte.
Right.
Correct.
All right, this is solving two major questions that there were.
Okay. So, we have Amendment 1415S. Is there any further discussion on the amendment? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, is there a motion on the bill as amended?
Move on to pass as amended.
Okay, Senator French moves ought to pass as amended.
Second.
Seconded by Senator Whitley. Is there any further discussion on the bill as amended?
I think it's a good bill. I think we've tightened it up and I'm happy with it.
Hey.
That is our objective.
Yeah.
That's right.
I would say, uniting the process in criminal court makes sense for the beneficiary. It's simpler. They get representation. I think that's important. I think And I think, this amendment hopefully really lines it up with our actual process in New Hampshire. Yep, so I think it's ready to go.
Okay. Is there any further comments or seeing none, all in favor say aye.
Aye.
Any opposed? No.
No.
I'm saying no.
Okay,
Okay, so Senator French, why don't you take this one out?
thank you.
There you go. Okay. Next, we have House Bill 1388, an act relative to the unsolicited disclosure of an intimate image. We have Amendment 1532S. And Rick, do you want to discuss this one?
Sure. The bill as introduced and as it came over from the House had a definition of consent that read, as an element of the offense, that the recipient has not indicated by speech or conduct that the recipient has freely consented to receipt of the image. That is a sort of cumbersome, and unusual way to go about talking about consent. Consent is a well-established concept in the law. It's all through all the sexual assault statutes. We know what consent is by saying consent, and I would indicate that if in the context of sending images back and forth, likely on a cell phone, the probable way consent would be manifested would be in a text. And consent by text wasn't specified in the bills that came over from the House. So legally, I think it's cleaner and more in line with established law to simply say the recipient does not consent to receipt of the image.
Okay. Any comments, any questions, any concern?
I would move the amendment.
Okay, Senator Khan moves amendment 1532S, seconded by
Mr.
Senator
Wide
Gannon.
Awake.
We have a new arrangement going on here.
Apparently. Whitley.
Everybody's changing it up.
Usurped.
Okay,
4-6.
okay. I was gonna say, there's gotta be like a magic pumpkin or somebody turns into a something at 6 o'clock. Okay, so we have an ought to pass motion on Amendment 1532S. Is there any further discussion on the amendment? One of the things I was concerned about, and it had to do with the texting, people send emojis. And could emojis be seen as consent or not giving consent? And I think this language covers that. So, okay, ought to pass. All in favor say aye.
Aye.
Aye. Any opposed? Okay. Is there a motion on the bill as
Madam
amended?
Chair,
Yes.
in advance of that, I just want to put this out there. I did not prepare anything. I need that. But we had a discussion about second, third offenses on this. And this simply says that a person's guilty of a misdemeanor. And I just, somebody can come back next year and adjust this clearly. But the fact that it's not progressive does disturb me. How many misdemeanor strikes does a person get before there's something that ought to have court?
And again, Senator, thank you for those comments. Looking at the hearing report, because what I was really concerned about were children under the age of 16 receiving unsolicited photos, and it's a felony. So we're talking about people that are 16 and older. And unfortunately, in today's society, a lot of teenagers, 16 and older, will send photos of themselves. Do we want to create felonies for these kids? I don't think that that's where we really want to go. But yeah, and you did ask if it's a second or third offense. It would remain as a misdemeanor as existing statute is silent on multiple offenses. And I do think, Senator, I agree with you that that is something that can be fleshed out next year. But I do think this was a bill that we had last year, and we went to a committee or conference and couldn't agree. And so I think it's important that we get this on the books. And if we need to flesh it out next year, we can do that. Or whoever's here next year.
Can I make an observation about that as well? Because I think that Senator Khan has brought this up on several bills about the idea of having progressive punishment, which is a thing that makes a lot of sense in the criminal justice system.
Right.
Even if you don't have it in the statute, though, it's already built in because judges will look at a person's record when it comes to sentencing. If it's a first offense, it's going to be treated one way. If a judge in a circuit court sees the same offense with the same defendant several times, they're going to start reacting in progressive ways. So that kind of thing's built into the system, even when it's not in statute.
In sentencing.
Do we have a maximum of 3 years on misdemeanors?
If it's a misdemeanor, the maximum is 1 year per incident. Now, how you carve up individual crimes it can be complicated, but if somebody sends 5 images, in theory, they could be sentenced to charged with 5 different misdemeanors and have 12-month sentences stacked on top of each other consecutively as well.
Right. Good.
Yeah, and think about somebody who sends a photo that they had received and that somebody sent them, and they sent it out to all their classmates. Hopefully their classmates did not consent to get this photo. So if you have a class of maybe 30 students, that would be 30 counts. And that can add up real quick. And I think we do need to give discretion to the courts in dealing with this. So,
All right, I move on to pass with amendment.
okay, Senator Khan moves on to pass with amendment. Is there a second? Seconded by Senator French. Okay, is there any further discussion?
I do think this is important. I know I have heard from, women younger than me that this is a harassment technique. They're in a coffee shop. So this is an issue that does need to be addressed. And I think this sort of balances all the issues that you identified.
Yeah, and I agree. I mean, I've heard the same thing, that people that are on dating sites receive unsolicited photos of other people. And it's, I was going to say it's
very creepy,
but you can't speak to modern dating. It's like, I'm not even going there. So we have an ought to pass as amended motion. Is there any further discussion? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay.
Move consent.
Senator Whitley moves consent, seconded by Senator Khan. Okay, so we have a consent calendar motion. Is there any discussion on the consent calendar? Okay, seeing none, all in favor say aye. Aye. Any opposed? Okay, and Jenny, I will do this again. I will take all the consent calendar. We don't have to stay tonight, do we? Okay, that's good. You can get home at a decent hour. Okay, next we have 1431, an act establishing the Parental Bill of Rights. Rick has an amendment, and you want to walk us through that amendment.
Okay.
This is amendment number 1646S.
The amendment makes a number of style and form changes to the statute and a couple of substantive ones. The first is a reference in 169I:3 to any other institution in the House-passed bill. My opinion is that any other institution would include private institutions, and you don't have any business telling private institutions that they have to relate to parents of people who choose to engage with them in this way. So that has been stricken from several places. In I:4, there was a reference indicating that parents have the right to be promptly notified if an employee of the state suspects that the child has been a victim of a crime. Suspects, sort of like consent on the last bill, isn't a real clear word with a legal meaning. So that is replaced by a reasonable basis to believe, which is a pretty well-worn standard that would obligate employees of government subdivisions to notify parents when the children have been notified of crime, of being crime victims.
Line number, please.
I don't have the line numbers in front of me. I'm sorry. Let me see here. It would be page 2, line 1, and line 2. And and as it came across from the bill, it retains the exemption if there's a thought that there is child abuse and notification of the parent would impede child services investigation. So if the child is a victim of abuse at the hands of a parent or of a crime at the hands of a parent, there's no requirement to announce it to the parent, which seems sensible.
Okay.
Next.
Down in Roman numeral 3, as it came across from the House, there was sort of a strange sentence that said a parent of a minor child has inalienable rights in the original statute, and then it goes on to say, unless those rights have been waived or terminated, parental rights that are waived or terminated are alienated. So it was a sentence that contradicted itself. In the new construction, it simply says that the parental rights are more comprehensive than set forth here, and that this statute doesn't seek to indicate what all parental rights are. So it's a parental right that may exist but isn't included in the statute continues to exist. You're not exterminating any common law rights the parents may have.
Okay. Let's see.
Moving on to I:5, parental rights in education. These remain the same until you get down to paragraphs F and G. Those are the major additions. And the motivation that was communicated to me was to try to identify instances in which parents are going to want to be notified by school information that's relevant to their kids. So in paragraph F, most of these in paragraph F existed in the House passed bill that I believe.
Well, what's different?
I'm sorry, paragraph F is mostly additions, but it creates a right for parents to be notified when students change their course of study. I mean, you can see the list. When there's discipline imposed, services are recommended for special ed services, whenever Medicaid services are delivered through the school, Title I services are delivered through the school for free and reduced lunch, when your child will be participating in off-campus activities, and when the child will be receiving treatment, and when directory information is being changed. The statute would trigger an obligation for the school to notify parents of those things. Paragraph G does a similar thing, but was sort of arrived at differently simply by going through school lists of policies and finding lists of things that most parents would want to be aware of. And obviously, if people think that some of these should be excluded or other ones should be included, it's certainly every senator's right to propose amendments, but it creates a right for parents to be notified promptly when a school board or school district investigates a student either as a victim or a perpetrator or a person involved in violation of various school policies that exist in most school districts, including all kinds of student conduct, truancy, dress code violations, sexual harassment, bullying, hazing, behavior management intervention, substance use, suicide prevention, changes in school records relating to gender expression or identity, disability accommodation, and special meal prescriptions. Again, that's going to be an incomplete list because schools have policies, more policies than that, but I was tasked with trying to flesh out things that parents would be interested in hearing about, and those were the ones that stuck out to me the most.
Okay, so what's next?
The last part is mostly deletions from the House passed version. The House had criminal penalties for public employees who violate any of the provisions in here, making it a misdemeanor. That was stricken. There is a provision that allows parents to go to court to seek civil remedies, injunctions, and declaratory judgment and collect attorney's fees if they prevail, but the penalty section has been removed. And that's about it.
Okay.
Yeah.
Yes, please.
So, I appreciate the work on the amendment, but I don't think it does nearly enough or anything to address the significant concerns we heard from child advocates, from our Office of Child Advocate to folks from Waypoint who see what happened to, what parents are capable with children. Like, we're in a situation where for decades we have undermined our child protection system. We are now working together in a bipartisan way to build that system up, right? And we're doing that because there were high profile cases of child deaths, right? And then also we have this other situation looming over us with Harmony Montgomery. And so I just feel like anything to interfere with our ability as a state and elected officials to protect children is just something that I can never support. And I just feel like, we heard so much testimony about how the bill itself, is vague, it's overly broad, and in many instances is just completely unnecessary. There's, there are very clear and defined rights already in existing law for parents. I'm a parent myself. I, of course, feel like, parents need to have their voice, but I do feel like nothing I heard told me that parents' rights weren't considered, and that when we are thinking about adequately balancing child safety, we don't want to be putting child safety or child rights in conflict with parents' rights, and I feel like this bill does that. I don't think the amendment does much to address that. And we got a letter from, a really troubling letter from Joe Ripson, the director of DCYF, said to the committee, unfortunately, he wasn't here for the bill, but he did send us a follow-up letter. It said that the bill is so broadly written that there's this is a quote, is so broadly written that there's a high likelihood of interference with DCYF's mandate to investigate child abuse and neglect and to provide care for the children in our supervision, care, custody, or guardianship. And I don't see anything in the amendment that addresses that issue. I think in schools, it's a tough time. I understand in schools, parents feel like, they want their voices heard, and I get that. But I don't think, elevating the rights of parents over the rights of children is going to solve that issue. Certainly, there are other ways to address that issue, and we should be listening to our constituents to help them do that. But having a bill that's going to put children at risk is just not the answer to that. It's just so broad. I mean, I would certainly be willing to work with this committee or other elected officials to think about how we can elevate parent voice, but never at the expense of child protection. And I think we also have a situation, and my child's in public school, where, it's a high tension time right now. And there's already sort of this fear and distrust, I think, between parents and administration and teachers. And I think this bill doesn't give people extra rights, but it's going to just further that fear, that mistrust, I think, that's happening right now. So I think we would be doing a disservice to add fuel to that right now. So I appreciate the work for the amendment, but I just don't think it does what we needed to do. And I think I really hope that we don't do anything to interfere with the state's ability to protect children.
Okay. Is there any, Senator French?
I think the first line of defense in protecting our children lies with our parents, and this helps solidify that fact. So I would move on to pass of this amendment.
Okay, are you making a motion on to pass? Okay, seconded by Senator Gannon. Okay.
Madam Chair,
Yes.
I'll be voting against the amendment.
Yep.
When I see it on page 2, number E, or letter E, excuse me, I don't think there's any anything we can do there to improve the language? There's a reasonable basis to believe that a criminal offense has occurred. This is exactly what I think Senator Whitley was talking about, putting schools at odds with their practice, with what they're charged to do. If you see it, report it. They're charged to do that. Who would want them not to?
Yep.
And to just, I mean, they do not, I mean, just because it's reported doesn't make it so. And that's why it's handed off to the appropriate state agency, which is DCYF. And that's the way it ought to go. It doesn't, I mean, that section introduces something that I think is an unintended consequence. And for that reason, I'll oppose this. I think also, we haven't tried to go through this and see what is in our current education chapter as to what rights parents already have. A lot of this is already covered. And to put this in 169 is not a good place for school officials to rely on this kind of language. This turned into a parent versus educator bill. I don't know if that was the original intent, but that's what's happened to it. And I don't think that we have dealt with this properly, with proper amount of conversation and the proper people coming to talk about how does this get addressed more sufficiently than it already is in current statute. So for that reason, I think this motion is not the correct motion. I think the whole action on this is premature. And I personally think we're missing the target. We ought to be aiming towards, if we want to work on this, then let's do it. Let's do it under interim study. Let's not ram this through, which is what I feel we're doing.
And I will just say to Senator French, we're all parents on this committee. We care deeply about our children. We would do anything for our children. I know that. I know all of you and are wonderful parents. But unfortunately, not all parents are like that. And I have worked in this arena, and even though most parents do their level best for their children, this bill would expand the rights of parents who do abuse their children. And so I don't think that we as a legislature want to be expanding the rights of parents who abuse their children.
Any further comments? I'll weigh in on this. I look at on page 2, on lines 1 through 5, where they talk about where they believe a criminal offense has been committed. But then it says, unless the incident has been reported to law enforcement or the Bureau of Child Protective Services, and notifying the parent would impede the investigation. I think that in many respects, we've forgotten who is ultimately responsible for the children. It's not the schools, it's the parents. And I think we all know that there are some parents out there that probably never should have been parents. And there's nothing we can do about that except to try to create an environment where a child is going to be safe and the child will have the opportunity to grow. But we can't create a law for every single situation. The parents have the right to know what's going on with their child. They seriously do, because at the end of the day, they have the ultimate responsibility for that child. I mean, we all know that everyone who works for a school district, they're mandatory reporters. And if they see something, they have to report it. But I think the language in that first section takes care of that. And I also think that this bill took out some of the things that I think we all can agree with. The fact that teachers were going to be, could be arrested for misdemeanors, and that is not conducive. That doesn't solve a problem. And so that was gone. And what I see this amendment as doing is that it's creating a balance between the two, between the parents and between the schools. And is it a perfect balance? No, it's not. But I think it goes a long way, and than what we received. We have a more balanced version of the Parental Bill of Rights. But then you ask, why do we even need to have a Parental Bill of Rights? And it's because over time, parents have lost more rights over and over and over again. And I just come back to the fact that parents, they're the ones that are ultimately responsible for their children. And if they don't know what's going on in their children's lives, how can they help them? How can they support them? I know because Senator Whitley and I have done quite a bit of work with kids, but I don't automatically think every parent is a bad parent. I think everybody does the best to their ability. And I think we all know parents make mistakes. Our parents made mistakes with us, and we've probably made mistakes with our children as well. But parents do have the right to know. And why have we put that burden on our schools? Why? Parents have pulled their children out of school. They're homeschooling them because they see things going on in school that they don't like. They don't want their children exposed to. Don't they have a right? You go to the local school board and you try to talk to them. That's even if they give you time to address them. Parents are increasingly getting frustrated here. So I think that this bill goes a long way. I think it takes a more measured approach to what we had received and what we heard in the public hearing. And I will be supporting it.
Madam Chair, I just want to come back on that item on top of page 2. It has a reasonable basis to believe that a criminal offense has been committed.
Mm-hmm.
A criminal offense.
Mm-hmm.
A child walks into a classroom with a broken arm, maybe another occurs. A teacher reports it.
Yeah.
They have not indicated that that was a criminal offense. I don't think we want to put a teacher, anybody in the school, in the position of having to determine, was that a criminal offense?
I understand that. But if you have a child that comes in that has a lot of bruising, usually someone's like, well, what happened? You know, did you fall? Did you hurt yourself? And the child will usually tell you, this is what happened. If you see it repeatedly over and over and over again, I think that's a reasonable suspicion. And teachers do report those things, as they should, because they are mandated reporters. So, and again, I think that there's enough protection in here that says, look, if they think the parent is the person that's causing harm to the child, they're not going to tell the parent because it would impede the investigation. And I think that protection is in there. I don't think teachers make frivolous reports as mandatory reporters. I think they're very careful about what they do. And I want to say, I think they even receive instructions on mandating reporting, much more than anybody else, because they're in contact with these kids every day. So you don't want to put the teacher in the position of making that report and then having to notify the parent and then having to deal with an angry parent. They're just not going to tell the parent. And the law enforcement or the Bureau of DCYF is going to do their thing. They're going to do an investigation. I do think that that protects the teachers, that they still can report, but if a parent breaks a child's arm, that's a crime. That can be considered a crime. Or if a child is being beaten, that is considered to be a crime, and that is reportable, and they will report it. But I would suspect, if a child's being beaten, or if a doctor suspected that, the broken arm, I think they're called green stick fractures, where it's a twisting kind of a fracture. That's usually what a lot of kids will get when a strong adult, grabs their arm and twists it. It snaps the bone. That the doctor would be reporting something like that as well. So I just don't see the teachers as being the only ones doing this. But it does say, look, if it's suspected crime, you call law enforcement, DCYF, and you're not going to tell the parents because you realize you're putting the child in a very difficult position. So I do believe that that's covered, Senator.
Well, we'll
continue. We'll
disagree
discuss
on
it.
it
Yep.
because I
Okay.
think that the responsibility to have to notify the parent on something that's just suspicion, and that all it does is just go from a teacher to a guidance counselor. At that point, it's just, I don't think this is describing a situation that you've described.
Okay.
You've gone to a point of arriving at a conclusion when this is merely saying, when what a teacher is likely to be reporting is just a guess, a concern.
Right.
And a concern, the way I read this, requires a notification of a parent.
Well, it says they have a reasonable basis to believe that a criminal offense has been committed. So it's not going to be frivolous. It is going to be something very serious. And then it goes on to say, unless the incident has first been reported to law enforcement or the Bureau of Child Protective Services, and notifying the parent would impede that the investigation. So if it's serious enough that you're calling in the police or you're reporting it to DCYF, they're not going to notify the parent because that would be impeding the investigation. So I do think that, again, that it is covered. Senator Whitley?
Yeah, I would, well, a couple things. One, the criminal penalties were removed, and now we have put in another section that in the amendment, any parent claiming a violation of any provisions of this chapter may bring an action for declaratory relief, injunctive relief, and money damages against the state. Not only that, but if the court finds in favor of the parent, it can award attorney's fees and court costs. So we are going to set up, it's already a heated situation. We're going to set up, even more, we're going to, again, put fuel on the fire towards this, pitting educators against parents and, creating this litigious environment, which I think is just over the top right now. And I think, we heard from our Senate president that if these bills need work, let's just hold it. And we heard countless testimony about how does this bill interact with the rights of other parents in the class in terms of directing curriculum. How does this bill go beyond what's already required in 91A? What about, how is this different than an existing requirement in 18611 about school districts, having to supply curriculum? I think there are so many open questions here about child safety, about how this interacts with existing law, about whether this is, there's just so many open questions. I just think that we should heed the suggestion of the Senate president and send this to interim study, hold off, and address the real problem, which I, heard loud and clear from Senator Carson, that parents don't feel like they're getting adequate voice in the schools. Let's deal with that. I'd love to deal with that with you next session. But there are just so many areas that in this bill that are so problematic that are going to pit kids, the rights of children, the right to have safety, the right to be free from abuse, to the right of parents. We're pitting educators against parents, in an unnecessary way. I don't see anything new really in this law that isn't addressed in current law. But the harm is potentially very problematic. And so I think if we can just slow down, interim study this, really think about this before we do real damage to our kiddos and before we do real damage to the already fragile relationship between our educators and our parents right now. So I think we should heed the Senate President's warning to us to just slow down, interim study this, and we'll work on it next year.
Okay, are there any further comments, any further questions? We do, Jenny, I believe we have an ought to pass motion on Amendment 1646S. Is everybody ready to vote? Okay, all in favor say aye. Aye. Any opposed?
No.
Okay,
Move
so
on to pass as amended.
Senator French moves
Second.
ought to pass as amended. Senator Gannon seconds. Is there any further discussion on ought to pass as amended? I think we've pretty well discussed this. So is there any further discussion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed?
No.
Okay, who would like to take this one out? Which one are you?
I'll take it out.
Okay, Senator French wants to take it out. Okay. Next, we have the HB 1476, an act relative to persons arrested while out on bail. We do have an amendment, but I think I gave my amendment to Rick. Oh,
1613.
no, this is not it. Senator Bradley's.
I'm sorry.
Okay, thank you. So Rick, do you want to walk us through this one as well?
Yeah, so Senator Bradley's amendment takes the bill that Representative Barry brought in. His bill dealt mostly with Section 7 of the bail statute, which was different than the part that had mostly been changed back and forth over the past several sessions. This amendment identifies a class of crimes of people who come in who are going to be detained until they can go in front of a judge and not be released automatically by a bail commissioner. The list is at the bottom of the first page and top of the second page, the various crimes that are identified for that treatment.
Okay. Some of this we've seen before we saw some of this last year and we saw some of it this year again. And the bill is currently over at the House. So is there a motion on Amendment 1613S?
Move on to pass.
Okay, Senator French moves ought to pass. Is there a second? Second by Senator Gannon. Okay, discussion.
If I may.
Yes,
Okay.
please.
So this is nothing new. I still find it really problematic. The amendment would still mandate the detention of people charged with any of these offenses prior to, arraignment, pre-trial, based on, only on unsubstantiated allegations. I want to make it clear again that current law already allows the court to detain any individual pre-trial if they are a flight risk or a danger to our community. That is already the law right now, right? I think, we have heard that there are problems with the existing process, but this is not the solution. There are other solutions, including enforcing current law, which allows people to be held if they are dangerous pre-trial. That's the law right now. And I think the court is really best equipped to determine who is dangerous. And I think that they should retain that power. I think this amendment, again, takes away the court's power to do those individual determinations. right? In all these circumstances, because we're talking about depriving someone of their freedom, of their liberty before they have, potentially on unsubstantiated allegations, right? I think it's important that we're very clear that we are flipping our whole system on its head, right? And we are taking that discretion away from the courts. And I think, when we're making policy, it's really important that we do so based on data. And we have not received the data that bail reform that happened several years ago is making our community safe. That's, unsafe. It's just not, we have some anecdotal stories that are problematic. I totally agree. But we need to think about how in those situations, what went wrong? Why weren't those people held? Why weren't they considered dangerous by the court? That's the problem that we need to solve, not flipping all the reforms we did on their head. So I just don't think that we should, be enacting laws to deprive freedom of thousands of grant staters, to sweep in all these people who are potentially not guilty of these crimes without very, very clear evidence, right? Without the data. And I think legislating without that data is really dangerous and problematic. We are supposed to be the state that is number one in freedom. And I think passing an amendment like this, bills like this, is antithetical to that.
Okay, Senator French.
So Senator, could you turn to page 2 of the amendment? Could you tell me which one of these offenses you would think the person shouldn't be held for 36 hours after the arrest to wait for bail? Which ones?
Senator, you had an amendment that, we could potentially have worked on together. That is something that,
I know, but
Senator, we would have considered that if you wanted to talk about taking some of these out, we can do that. But the amendment before us is not something I can support.
But don't these cover basically those crimes that we discussed? I mean, what on there wouldn't you want someone held for a mere 36 hours?
I think it sweeps up. Again, if someone is charged with this, if there's a potential that they are dangerous or a flight risk, they can still be held under current law.
Right, so this spells it out. I mean, I voted for
categorically without any individual determination by the court. We are taking away discretion of the court right here. And holding people, even if they haven't been, right? What happened to the whole notion of, guilty,
I know.
innocent until proven guilty? We are flipping that on our head, that head.
Yeah, I disagree.
I think that's antithetical to the principles of freedom that apparently the state, values so much. Antithetical.
Well, I'm just going to weigh in here. As someone who was sitting here, in fact, sitting in the chair, when bail reform came in front of the committee, we were assured over and over and over again that it wasn't going to apply to people that had been accused of committing a violent crime. And what we've seen since is not what's happened. And that's why there has been repeated events, times that we've tried to make this correction. And we have seen people who have been accused of violent crimes be let go and go out and commit another violent crime. We just need to get the parameters put around it. 36 hours is not a long time to get somebody in front of a judge and have the judge make the determination whether or not they need bail. We've got to stop this revolving door where people just come in, they committed some sort of a crime, and then, because of bail reform, they get let go. We need to address the violent crime, and that is what bills that have been filed over the past couple of years have tried to do, is address people who have been accused of committing a violent crime. Domestic violence, aggravated felonious sexual assault under a different statute, kidnapping, stalking, trafficking, robbery, possession, manufacture, distribution of child sex abuse images. I mean, these are violent crimes, according to our statute. We're not making this up. This is already in statute. So I'm going to be supporting amendment number 1613S. and provide clarification to the court and say, people who have been arrested for these particular issues, have been accused of these issues, they must be held for 36 hours at least in order to see a judge and have a judge weigh the evidence.
Well, not more than 30.
Yeah, not more than 36 hours. When we had this, it was sold to us as, well, you know, you get somebody who, you know, committed a petty crime and they're going to be held and, you know, to wait to go in front of a judge and they're not going to be able to, you know, they're going to lose their job. And if they lose their job, they're going to lose their housing. They're going to lose this. And we agree. For small little petty crimes, that's one thing. But when you're talking about serious offenses, please just let the judge look. Let the judge go ahead and say, okay, we've got to look. Let the judge do that. And I don't have a problem with that.
Madam Chair.
Yes.
You know, so we saw, you know, some language earlier that landed on violent crime. And I agree with you. We need to swing the pendulum back. I just want to find someplace that doesn't swing too far. And you know, not all of these are violent crimes that we've listed here, and I'm feeling that I think there's an amendment that I would vote in favor of, and this isn't it.
Okay.
And we also heard testimony that the backlog that's in the courts is significant.
Mm-hmm.
And that these cases where somebody is held, we aren't going to be able to get adequate defense for them in a timely manner. And it makes me wonder if our system is going to get overloaded with these kinds of hearings, so that have to take place in 36 hours. It just feels like we can take a step and swing the pendulum back. We don't have to do as far as this amendment goes. And that's why I'll vote against it.
All right. Is there any further discussion on Amendment 1613S? Okay. Seeing none, all in favor say aye. Aye. Any opposed?
No.
No.
Okay. Is there a motion on the bill as amended?
Move on to pass as amended.
Senator French moves on to pass as amended, seconded by Senator Gannon. Is there any discussion on the bill as amended? Okay, seeing none, all in favor say aye.
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 Aye. Any opposed?
No.
No.
Jenny, I'll take this one. Okay, we do have a bill, well, we'll wait and we'll do that one last. Next, we have House Bill 1540, an act relative to recording custodial interrogations. Is there a motion?
For interim study.
Senator Gannon moves interim study. Is there a second?
Second.
Seconded by Senator Khan. Is there any discussion on the interim study motion?
I mean, yeah, I think this is a timing issue. I think this bill has merit. You know, I do think there was an amendment that we could potentially get behind, but I think we just sort of ran out of time.
We got bills so late that we just didn't have time to do the necessary work. And that's why I said we can't have this compressed schedule. It's just too much, not enough time. So we have a motion of interim study. I mean, we had, I believe, some pretty compelling testimony from the Assistant Attorney General saying that it turned the statute on its head and the penalties are too much. So I do think that it probably does have some merit, it's just not there yet. And it would take an incredible amount of work to figure it out. So we have a motion of interim study. Is there any further discussion?
I guess it bothered me because the Griebel case was so heinous. he stopped his custodial interrogation and then confessed, and we were told that that confession would be admissible. So
Okay.
that bothered me.
Okay, so we have a motion of interim study. Is there any further discussion on the interim study motion? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, is there a motion for the consent calendar?
Move consent.
Okay, Senator French moves consent. Is there a second?
Sure.
Senator Gannon seconds. Is there any further discussion on House Bill 1540? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, Jenny,
So we can
mine.
take that out.
Yes, I
Thank you.
will. You're so generous, Senator French.
That's a good one.
Okay, next, we
1493.
have House Bill 1677. I move on to pass.
I'll second.
Senator French moves on, seconds. We did get an amendment, but that amendment is, hopefully is gonna go forward to House Finance. This is really a fiscal bill, and it really belongs in finance. And by, pardon?
What bill? I'm sorry.
This is 1677. Yeah, I know this is, yeah, it is an FN bill. So we have to get, this has to be out of our committee today. This is I think a work in progress, that more work needs to get done with this. It will get to finance, and they will have another week or so in order to work on this bill. And hopefully, they will reach a consensus among all the parties. I think the amendment that we did have, went towards that motion, but I just think that we just need to get this bill to finance. And we don't want it to die. This bill is incredibly important, and so they really need to look at the fiscal aspect of this bill. Senator Whitley?
Yeah, I would say this bill is maybe one of the most important things we're going to do this session. You know, the amount and horrific abuse that happened at YDC it makes my stomach curl, roll. And it's something that has, kept me up at night. And I think so many people, the magnitude of the abuse was just so dramatic. So, I do think there are many people working on this, and I do think that they will get to a point where it's workable. I think it's worth the work because it's a pretty unique approach to a very, very important problem. I just think every time we talk about this bill, and we just have to ground in the fact that, this was significant abuse, at the hands of the state. And these were most vulnerable children. And I think they need to be made whole.
I agree. And so, as I said, this is a work in progress. And by no means is everything said and done. So we just need to get it to finance so they can start working. Senator, they already are working, I should say. Senator Khan?
Yes, thank you, Madam Chair. So I just don't want us to do consent on this.
No, we will not do consent on this.
Because
Yeah.
I think important, and I don't want to screw up the technical term, right? The issue of emotional abuse was presented, and I think convincingly so for me, relative to this bill. Would it be enough to interfere with the process of moving this forward? Because this is important. It's got to come out of this legislative session. It will benefit nobody in a way on this.
Right.
But I just want to make clear that I think it's important for us to speak to the matter of emotional abuse as a recognized offense that the state is prepared to receive complaints and act upon them.
Yeah, I couldn't imagine putting this on the consent calendar. Well, I think we'll all have an opportunity to stand and speak on the floor. So those of our members who are on finance will get a pretty good idea about where we are and what our thoughts are as well. So, no, it's not going on consent. Okay, so we have House Bill 1677. Do we have a motion, Jenny? Okay. Okay, ought to pass, that's right. Okay, so is there any further discussion on the ought to pass motion? Okay, seeing none, all in favor say aye. Okay.
Let's vote. I want to say something about
Okay.
it afterwards, but.
All in favor say aye.
Aye.
Any opposed? Okay.
What has happened to the bill that we sent over to the House?
Which one?
One that was like this.
You're talking about the bill that closes the Synonymous Youth Services Center?
I imagine if it's over at the House, hopefully it's gone through a policy committee and it's in House Finance, but I don't know. I mean, that would be their process, is to have the public hearings and then it would go to a second committee. So, and I think it would be heard by, I want to say Division 1, I'm pretty sure. Who knows? Yeah, so I don't think it's through their process yet either. So that's where it is.
Right.
Why do you ask?
I think they're connected, and
I would suggest you have a conversation with Senator Daniels. He would probably have a better idea where it is and what's happening with it.
will do. Thank you.
Okay. So we have I want to say, who wants to take this out?
I'm happy to.
You want to? Okay. Yep, Senator Whitley.
Keep it short.
Okay. Jenny, does that take care of all?
All of our offense.
Okay, all of our, yes. Just so you know, and you can tell by our master sheet, more than half, if not 3/4 of the bills we had were fiscal note bills, which was incredible. We've never seen that many. So they are finally done. We have one that we could probably do today, that we heard this afternoon. It would be House Bill 1493 relative to the drug forfeiture fund.
And I would like to make a motion of ought to pass.
Okay, so we've got a motion of ought to pass, and seconded by Senator Gannon. Is there any discussion? I think this was pretty straightforward. It's about increasing the transparency. We tried to do it one way. It wasn't working very well, so now
Do
we're
it
going
again.
to try it in a different manner by requiring they put it in a report that they give. So hopefully that will work. So I think that this is entirely appropriate. And so we have a motion of ought to pass. Is there any further discussion? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed?
Move
Okay.
consent.
Senator French moves consent. Senator Whitley, is there any discussion on the consent calendar motion? Seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Nope. Okay, Jenny, this one's mine. Okay. So is there anything else to come before the committee? We won't be scheduling probably until maybe tomorrow, Jenny. I'll find out a little bit more. If we can't do it, we can't do it. And so we'll just schedule for the afternoon. And we'll just have to plan. Wait, I'm not done. Oh, I know you want to go. No. So we'll have to do what we did last week. Where we're gonna hear the last 6 bills, and then we have to exec everything in that afternoon. So, okay. Now, Senator French.
I move we come out of executive session.
Is there a second?
Second.
Second by Senator Khan. All in favor say aye.
Aye.
Any opposed? Okay, we are done for the day. Thank you all very much for all your hard work. We got one more day of hard work in front of us next week, and then we'll be finished. So thank you all, and have a good evening, everyone.
Thank you.